Well, actually, I think I've got 846 over there. Commissioner Butler, will you say a quick prayer, please?
Sure, sure. Lord, thank you for bringing us together again today. Imbue us with your goodwill, Lord, as we proceed to adjudicate these cases that come before us, all the matters that come before us today, Lord. Guide us with your loving hand. You are the all-powerful Lord. You guide us and you protect us daily. We live and breathe through your will. And we ask you to help us make the right decisions for the people that come before us, for the employees of this great agency, and us as commissioners, Lord. Protect us as we go back to the various parts of the state from which we came from. And we ask this in your loving name. Amen.
It is 8:46. As I mentioned, I'll now call this meeting to order. Ms. Mahon, will you call roll, please?
Monica Mendez,
Present.
Tom Butler,
Here?
Helen Collier,
Here.
Rick Figueroa,
Here.
Catherine Rodwald,
Here.
Robbie Shaw,
Here.
Deborah Yurko.
Here.
We do have a quorum present. We'll now move on to item C, executive session consultation with the attorney pursuant to 5510711 of the Government Code to receive a briefing from legal counsel concerning pending or contemplated litigation or settlement offers. 2 would be advice from attorney on legal matters authorized by 5510712 and under section 5510774 of the Government Code, discussion of personnel matters as it relates to the executive director. We'll now enter into executive session. to discuss out of executive session or take action on. We do reserve the right to enter back into executive session at any point in time during this meeting. Move on to item E, which is approval of minutes. Commissioners, you've had a chance to review the minutes. Your motion would be in order.
Mr. Chairman, I go ahead and approve the minutes.
Second.
Motion and second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. We'll now move on to item F, discussion and possible action to elect the vice chair of the commission. As you know, we had this in our last agenda. It was pushed back in order to ensure that we had a full agenda, a full commission. And we now have a full commission. So we'll now open the floor for nominations to be vice chair of the commission.
Mr. Chair, I want to jump in here and nominate Tom Butler as the vice chair.
Oh, here we go again. Okay, we have Tom Butler. Any other names being pushed forward?
And I would nominate Deborah Yurko.
Deborah Yurko. Any other names to be moved forward? I don't know if we have to have speeches by each one of you.
Speech.
Any other names? Okay, I'll just go ahead and close it there. We have Tom Butler and Deborah Yurko. Is there I guess, would you care to say anything, Commissioner Butler, Commissioner Yurko? I would open up Commissioner Yurko if you're interested. If not, we move forward. Commissioner Butler, if you're interested, not, we'll move forward. I can tell you that this becomes a very dicey situation because I think that we have two names that would be outstanding as vice chair. My fear is that they'll be greater than the chair, but.
Let's vote.
So, I want to kind of.
Talking about you.
So, let's go ahead and move on. If you don't mind, just kind of raise your hand as we put the name forward out there, and then I'll kind of count. If Ms. Mahon, if you'd help me count also, we'll kind of go from there. As in order of nomination, Tom Butler. So if you don't mind, Tom Butler, everybody's name for Tom Butler. Okay. And Commissioner Yurko. Those for Commissioner Yurko.
Can you vote twice?
Okay, I missed something because I've only got 3-3.
You didn't vote.
You didn't vote.
Oh, who'd you vote for?
1, 2, 3, 1, 2, 3. You're the-
Oh, okay. Oh, this is just great.
You get to decide.
Right.
Good luck.
Mr. Chairman, we can cue the dramatic music at this moment.
Yeah. Actually, can we just turn the lights off and I'll raise my hand? That'll make it so much easier on me.
Or we can put it on Brad.
I guess it wasn't seen. If you go back to the video, you'll see I raised my hand for Commissioner Butler, but I did not see Figueroa's hand up. So that was what it was. So we'll have Commissioner Butler as the vice chair. So congratulations.
May I make some comments now?
Sure. Now he wants to speak.
Yes. I'm not sure I'm the best choice for this, but I'll accept it. I've often thought of myself as a second among equals, not a first among equals, but thank you. I will try to do a good job for you. There are some things I'd like to talk about. I think in the last couple of meetings that we've had, we've talked about TDLR moving forward. And I think we need to look at, Mr. Figueroa mentioned a while back, TDLR 2.0. It's been talked about TDLR health or occupational, some of these different issues. Now that we're becoming such a big agency and moving up the food chain in the state of Texas, we need to think about changing how we model what we do as a commission, change our strategies moving forward, upping our game, being responsible a little bit more for the outcomes and the processes of this agency and where it goes from here. It's only going to get bigger. That's a blessing and a curse. And so we want to mitigate the curse as much as we can so that we have those blessings and discharge our responsibility. So those are some of the things that I'll be working with the chairman about. He's brought some of these points up in recent conversations with me. And so I think we're going to have some changes here in the near future, and you're going to be seeing hopefully a lot more of us as commissioners as we engage a little bit more and take some more ownership in this agency. and where it goes, because we don't want to be caught unaware. The state is growing. Our agency is going to be growing. We have almost 700,000 licensees, if not more. That's not too far from 1 million. And so anyway, thank you so much for your trust in me. I'll do my best to do right.
Thank you. And I agree. I think that as we begin to start looking forward to the TDLR 2.0, it kind of resonated whenever Commissioner Figueroa said that. So we'll kind of move on from there. Let's move on to, and again, congratulations to you. That's a good point. Well, we've already gotten a vote. I guess because the questions come up, do we need to get a second on that and a vote? But I think we've already gotten a vote, so in this particular case, it's a little different on how we do
I think
that.
you followed a Robert's Rules of Order
Oh,
kind of
we're okay.
process by taking the nominations in order and voting on them, so I
Think we're okay then?
I think we're okay on that.
Okay, let's move on to item G. Contested cases, I believe we only got one speaker. Well, you know what, let's do this first. I don't know if she wants to stay here. Nina Jo Saint, what I'm looking at doing, going down to public comment queue. I think Nina Jo Saint is here with the driver's education, is interested in speaking to us. I don't want to have to hold you up if you don't need to be here. But, oh, okay, well then let's just wait until then. Let's go back up to G and let's do the cases. And Mr. Rennick, you're before us.
Commissioners, Robert Rennick from the Enforcement Division. This applicant seeks a cosmetology operator license. He had one previously that was issued in October of 2004, but he was imprisoned in 2006, which caused his license to be revoked by operation of law. And then in August of 2015, he applied for another license. With regard to his criminal history, in 1994, he was placed on deferred adjudication, community supervision for 4 years for felony theft. Only 4 months into that community supervision period, the applicant committed the felony offense of burglary of a vehicle. He was convicted of that crime in August of 1994 and placed on deferred adjudication for 8 years. So at that point in time, the applicant was on community supervision for 2 felonies. In July of 1996, his community supervisions were both revoked because of his use of cocaine, marijuana, and amphetamines. He was sent to prison for 6 years in each case. The applicant was released from prison in March of 1997. 14 months later, on May 1st of 1998, his parole was revoked for some unknown reason, and he was sent back to prison. He was released again on May 28th of 1998, approximately a month later. 11 months after that, the applicant committed another felony, at this time robbery. He was convicted of the crime in June of 2000 and sent to prison again for 5 years. He was released in July of 2003. As stated earlier, in October of 2003, the department took a chance on Mr. Muffler and issued him a license. But in November of 2004, we took a chance on him in October of 2004. In November of 2004, only 16 months after being released from prison and only 1 month after receiving one of our licenses, the applicant committed the felony offense of attempted sexual assault. He was convicted in December of 2005 and sentenced to 20 years in prison. And that was what resulted in his license being revoked by operation of law. The victim was a 19-year-old young woman. He was released from prison to parole in August of 2015. He is scheduled to be released from parole in November of 2025. 14 days after his release in August of 2015, the applicant filed the application which is before you today. He was born in 1975. He was approximately 18 when he committed his first felony and approximately 29 when he committed his most recent felony. The department is concerned about all the applicant's crimes, but is most concerned about the attempted sexual assault, especially given the applicant's habit of reoffending within only a couple years of each prison release. The ALJ recommends denial because of the severity of the crimes, because of the application was only filed 14 days after release from prison, because sexual assault's a directly related crime to the cosmetology occupation, and because there is insufficient evidence of rehabilitation. The department recommends that the commission adopt the PFD and deny the license.
Commissioners, any questions for Mr. Reddick? A motion to be in order?
Make a
Move that
motion.
we accept the PFD.
We have a motion.
Second.
Second, all in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item number 2, the Atlas Towing and Storing, Mr. Shirk. We also have, let's see, Mr. Venegas?
Ricardo Venegas, yes, sir.
Okay.
Mr. Chairman,
Have a seat.
Brad Bowman, General Counsel, I just wanted to, we put in front of you a request for a continuance from the respondent's attorney. I don't know if that's still on the table, but we informed the respondent's attorney that this would have to go before the commission to determine whether to grant a continuance, and there was a schedule conflict which we were not aware of apparently. And that information is in front of you, as well as the Enforcement Division's response, and I believe they were in opposition to.
And you have it, which is marked G1, which actually just kind of for notation say should be G2, but it actually is before us. Commissioners, if you remember, Atlas Towing came before us in our last meeting seeking a continuance because they were going to be, I believe, on vacation, the
I
attorney.
believe that's right, it was out of state.
There was no mention of a conflict of August the 24th, which they were aware that our next meeting would be on August 24th. There was no mention of it then they came before us again and now asking a continuance once again for a conflict because of a conference being held in San Antonio. Now, Mr. Venegas, I'm not sure if you're here to argue the case or if you're here on behalf of Atlas to be able to talk about the continuance. So if you don't mind, can you just state your name right quick and kind of answer that question?
My name is Ricardo Venegas, and I'm a managing principal for Atlas Towing.
Okay, so you're here for Atlas Towing and not the law firm?
I am here for Atlas Towing, correct?
Okay, so that being the case, of course, we still have the continuance before us from the attorneys. I know that the Enforcement Division is opposed to the continuance.
That's correct.
For that very reason, as I stated, they never gave us notification that they would also have a conflict on this particular day too, which they were aware of, from my understanding, ahead of time.
I don't know when they first became aware of the date of this commission hearing. I can tell you that on August the 4th, Mr. Frisch was sent notice that these cases would be considered by the commission today, and about a week later, he submitted his motion for continuance. You're absolutely correct in that the original letter that he sent in support of his first motion for continuance did not list today as a date he would be unavailable for hearing.
Okay, so I guess the first question is if the commission wishes to grant the motion for rehearing, I'm sorry, the motion for continuance, which is the second motion for continuance that we've got before us, or do we want to go ahead and hear the case? I guess that's kind of the position that we're at right now. So, commission.
Commissioners, the representing attorney did forward a schedule of activities that he had prior, along with the submission for
Do we have that?
continuance. In that schedule, it does show that he has a prior engagement through this court setting, through this setting here.
Did we get that information, Mr. Shirk?
It should have been attached to his motion for second motion for postponement.
Right, but
That's
did we
when I
get it on the
first received
first? Right. Did we get it on the first?
Yes, we
The
did.
first motion for
Yes, we
continuance.
did get it on the first motion for continuance.
So they listed this date as a conflict?
No, they did not list this date as a conflict. If you look at the vacation letter dated July 15, 2016, it lists many professional and personal commitments through June through December, and today's date is not on that list of prior engagements.
That's true. I don't see it on here.
I would note to the commissioners that in support of the first motion for postponement, he submitted this letter, and in the first motion, he requested a brief continuance, and in the first motion, he said, for scheduling purposes and provided that very same letter.
Are you aware of this letter that was sent out by David Fritsch?
I am not aware. I was informed by my representing attorney that he had,
He sent us a letter basically showing his revised vacation seminar meeting schedule, and August 24th is not on there. So while he did submit the dates, he did not submit this date. He gave us everything else, though. I need to be Mr. Fritsch. He takes a lot of vacation.
thank you.
So you're aware of it, so you now,
I now am aware.
okay. Commissioners,
Make a motion that we deny his request for continuance.
we have a motion to deny the continuance request.
I'll go ahead and second it.
A second. Any other further discussion, Commissioners? All in favor signify by saying aye.
Aye.
Those opposed?
No.
No.
Can you take row, Ms. Mahon?
Yes. Tom Butler,
Aye.
Helen Collier,
No.
Rick Figueroa,
Aye.
Catherine Rodwald,
No.
Ravi Shaw,
Aye.
Deborah Yurko,
No.
Mike Mendez.
Aye. Motion for continuance is denied. We'll now move on to the actual case, which would be the towing case against Atlas Towing. So, Mr. Shirk.
Commissioner Mendez, Vice Commissioner Butler, members of the commission, good morning. My name is Michael Shirk. I represent the department in these matters. The PFD now before you presents two separate enforcement actions. The ALJ found no violation in the first case. That would be TOW 2014-000934. And the department chose not to file exceptions. The administrative law judge's decision in that case was based on her credibility determinations of which witness to believe, which witnesses not to believe. The department has no legitimate basis to argue with how she assigned weight and credibility, and therefore is not asking for any changes in the proposal for decision, which found no legal violation in that case. I would note that in both of these cases, the proposal for decision contains one technical error that I think needs to be corrected. That is on page 2, section 2 of the proposal for decision, and also on page 9, finding of fact number 1. The proposal for decision gives an inaccurate license number for respondent. The license number is given as 00542298C. The correct license number for respondent is 5452298C. I'll move on to the second case that was encompassed within proposal for decision that's now in front of you. This is TOW 2015-0012-936. The administrative law judge found that the respondent had engaged in an illegal tow when he took a tenant's vehicle from her apartment complex, and in response to finding this illegal tow, the administrative law judge recommended an administrative penalty of $2,000 for performance of the tow. In this case, the vehicle owner, Ms. Sosa, returned from work on the evening of March 26, 2015, and parked at her space in an apartment complex which she was entitled to park at. She worked for, and the car was owned by, a car seller, Thunderbird Motors. Due to her concern that the dealer plate would be stolen at the apartment complex, she took the dealer plate off and put it into the car. Later that evening, the vehicle on March 26, 2015 was towed. Ms. Sosa phoned the San Antonio Police Department, and Detective McCulloch, who has come to this morning's hearing, began his investigation of the case. Originally, the respondent claimed that the towed vehicle was taken or towed because it was either abandoned or inoperable. This obviously could not have been true, though. As developed in the facts of the hearing, the vehicle had only been purchased by Thunderbird Motors 3 days previously and Ms. Sosa had driven it home from her work at Thunderbird Motors that evening. During Detective McCulloch's investigation, respondent's manager, Mr. Venegas, went so far as to tell Detective McCulloch that a paint marking had been placed on one of the vehicle's wheels in order to monitor the length of time that the vehicle sat idle and had not been moved. Detective Mahalik was told by Mr. Venegas that it was based on the monitoring of the vehicle because of these markings on the tire that it was ascertained that the vehicle was inoperable or abandoned. I have provided 4 copies of exhibits, and I don't know if you've received them. It looks like from Commissioner Figueroa that you have received them. These 4 exhibits were admitted in evidence at the contested case hearing. Pages 68 and 69 correspond to exhibits 28 and 29. They're photographs of the vehicle immediately before the tow, taken by the tow truck operator on March 26, 2016. Please note specifically that there are no marks on the right front tire. Pages 70 and 71 correspond to my exhibits 30 and 31, also admitted during the hearing of this case. These are photographs which were taken by Detective Mahalik when he went to the vehicle storage facility where the car had been towed. The vehicle storage facility was also owned by Atlas Towing and Storage, LLC. Detective Mahalik took these photographs on April the 9th, 2015, and you will note that at this point on the front right tire, there is a marking, a paint marking, which Detective Mahalik was told affirmatively by Mr. Venegas had been put on the car well before the tow for purposes of monitoring it to ascertain whether it was abandoned or inoperable. This was, in short, nothing less than an intentional misrepresentation made to law enforcement during the course of an investigation. Mr. Frisch filed exceptions to counsel for Atlas Towing and Storage. Mr. Frisch filed exceptions to the proposal for decision which argue, among other things, that a tenant's car authorized to be parked where and when it was at the tenant's apartment complex may be towed because it does not display an expired license plate or any license plate at all. This simply is not true, and it's a misstatement of the statutory rule. A tenant's car may be towed from an apartment complex if it doesn't display an up-to-date license plate, but that tow can only occur if the vehicle owner or operator or owner is given 10 days written notice before the tow. The evidence is uncontested that no notice was given before this tow. The ALJ's findings of fact and conclusions of law are fully supported by the evidence. There was no basis to conclude that the vehicle was abandoned or inoperable, and indeed, Mr. Venegas' intentional misrepresentations to law enforcement is probably the very strongest evidence that an illegal tow had occurred in this instance. For these reasons, staff argues and requests that the Commission adopt the PFD as written. If any need is seen for a variation, my recommendation, staff's recommendation, would be an upward adjustment of the penalty which is permitted by the enforcement plan. As you know, the Department's enforcement plan is not binding on the Commission. The Commission has, in the past, deviated significantly downward from the enforcement plan in its assessment of administrative penalties against respondent. In December 2014, an administrative law judge recommended that an administrative penalty be assessed against respondent for $4,000 for 2 Class F violations. Upon Commission review of the PFD on March 4th, 2015, the penalty was reduced to $2,000. In November 2015, another administrative law judge recommended an administrative penalty of $4,000 against respondent, again for 2 Class F violations. When this proposal for decision came before the Commission, it was voted on January 6th of this year to reduce the penalty to a total of $500 against respondent. These reductions, these downward deviations from the penalty matrix, were certainly calculated to be fair, while at the same time serving the purpose of deterrence, which is what administrative penalties must be calculated to do. However, deterrence has not worked. The imposition of penalties, the payment of these penalties, and having to come before this commission on a regular basis are seen by respondent as nothing more than a cost of doing business. They're easily soaked up by the profits he makes, and given the nature of this case, the past enforcement history, and the mendacity involved in this case, it's my strong recommendation the department use its statutory authority and make an upward adjustment to the recommendation made by the administrative law judge. Thank you.
Any questions for Mr. Shirk? Mr. Venegas, if you don't, again, mind stating your name for the record, I would also notate that the only thing the commissioners can hear was that information that was presented at the SOA hearing, and anything outside of that will basically stop you and say it's not allowed because it wasn't presented at that hearing. So, okay, if you don't mind, state your name for the record.
Ricardo Venegas, and I'm the managing principal for Atlas Towing.
Okay, go right ahead.
We're going to commence with the reduction of fees. The fees are not reduced by the ALJ. The fees are reduced by the commission. In accordance to the violations or the degree of violation that these offenses are committed, the ALJ is set and bound by a certain amount of fees that they can charge. And the commission here is able to reduce in accordance to what is presented here by myself and what is presented by Mr. Shirk. In all the situations or all the cases that the commission has, or that the penalties have been reduced, it's because the commission has seen it fit that the punishment does not fit the actual fine. With that said, the reason we're here is based on a lease agreement violation. And I have with me some documentation along with the lease specifically stating and giving notification to the vehicle owner that they were fully aware of the rules and regulations. They choose.
Mr. Chairman, I just want to make sure this is in the record, the lease agreement and those documents that are being referred
Yes,
to.
it is.
Was that presented at the SOA hearing?
Mr. Chairman, I do not believe that there is any discussion about this tow being based upon a violation of lease terms.
Well, and I'm not saying you don't have it and it's not a part of what you have there. The question I have is, was it presented at the SOA hearing?
It was presented at the
discussed
hearing.
by you and the prosecuting attorney?
The information that I'm going to be providing was all presented at the hearing, along as with the discovery that we admitted to the prosecutor.
I would ask Mr. Venegas to identify which exhibit he's referring to so I can check my records.
The first one that I'm going to hand him is the lease agreement. The second one I'm going to hand him is an actual notification given to the property, the vehicle owner by the property management.
Well, no,
What,
sir,
is
that's
that a
not
part
what
of
I-
the exhibits that was presented?
That is correct.
Which ones were they? What was exhibit numbers were they?
What?
What exhibit numbers were they?
I don't have that information because Mr. Fritchie is not here today. I don't have anything that I can look up on. I was hoping that he'd be here today, but
Okay, hang on just a second. We need to take a look and see if there's anything that shows
Absolutely.
those exhibits.
May I see those, please?
this is a notice of action. Notice to the residents.
While he's looking that up, I might make clarification. You made a statement that that the commission reduces and that the AOJ will reduce. The AOJ simply has a matrices of our penalty, has our penalty matrix. So the AOJ will follow that.
Correct.
Okay, so while the AOJ was not simply reduce it at their whim, they still have to stay within the guidelines of
Exactly.
the matrix. So I just wanted to clarify that, because it sounded like you were saying that AOJ can do whatever they wanted, but that's
No,
not the case.
absolutely
Okay.
not.
All right, just want to clarify that.
Mr. Chairman, I find neither of these documents to have been admitted during the hearing.
Okay. If we don't show those documents presented in the hearing or exhibit of it within what we have, we're not able to present them at this time.
Although they were presented to him in discovery,
It would be only in what was presented at the hearing.
okay. Okay, I understand that.
Anything else?
The property that we have in question is contracted that to be a request property only. Basically, that means that the towing company can't choose and decide or pick and choose which vehicle is going to be towed or hauled off. This specific vehicle was called in by the maintenance supervisor to be removed. And at that time, it was removed. We don't just show up to the properties and start towing whatever we like because they meet the inoperable or the abandoned criteria. However, this vehicle was specifically ordered to be removed by this maintenance supervisor. And when the detective was conducting his investigation, the property management also made him very aware that we were authorized to remove this vehicle, specifically because the leaseholder had been previously informed that she cannot conduct an auto sales business from in that property, meaning that when they buy vehicles from the auction, the first thing they do is they take 5 or 6 vehicles to the property.
Objection. This far exceeds the scope of testimony that was given during the contested case hearing. That is to say, the operation of a business from the parking lot.
Oh, me? Okay. I'm sorry, I was listening to Yurko as well. Please, your testimony should be limited to what was in the SOA hearing and nothing more, okay? I know that's hard.
Commissioners, I mean no disrespect. I'm not trying to make more time. If I say something that's out of content, I'm not trying to be belligerent or just out of content.
Can I make a comment? This is Commissioner Yurko. We've actually postponed several cases in the past, 2 and 3 times when there have been conflicts. And I think this issue is a lot more complex than maybe we originally thought. And I would encourage that we reschedule this till counsel can be present for this gentleman. I just think it puts him in a very awkward position to try to answer our questions without having counsel present when he was anticipating having counsel present.
Duly noted. I can tell you, I'm of the opinion that we need to reconsider our vote unless I have other commissioners that are for it. But it will be noted. I can also say that in the event that your information was presented at the hearing, then there's other administrative avenues for you to be able to take further on from here that would allow us to reconsider that. So unless I hear different from commissioners about reconsidering, then we'll just trudge forward.
It would be my preference to reconsider, to delay.
We would have to,
Give them 1 chance.
and I'm perfectly fine with considering that. If you want to have a motion in that order, we can vote on that, whether to reconsider or not.
May I ask a question?
Sure.
Through the chair, help me understand, commissioners, why we would want to postpone this case for today when everything in the transcript has been written. I mean, all the information has been provided to us. Give me a reason why, help me understand why you would want to postpone this case.
As a courtesy in the past, when counsel can't be present, when they have retained counsel, we have honored that request before. We have done it on numerous occasions, and I just think it's a little unfortunate that we chose not to this time.
So if I can beg your pardon on that, based on the information that was provided by the attorney and the timelines that they were out or would not be available, I go back to the memorandum. It does not indicate that this date that they were not available.
I understand, and now he's not available, and we have done that before for other attorneys.
But, and I would make note that while Commissioner Yurko is correct, I'm also aware of instances that we have not granted a continuance.
Well, we
And
haven't,
most of the time
we
we
usually
have.
warn the attorney that we're not doing it again. And we've
So-
done it when we've had respondents who have just done it repeatedly over and over and over by text or by phone call in. But usually when an attorney has, when they've made the effort to retain counsel and pay counsel and counsel has not been able to make it, we have usually, on numerous occasions, given them 1 and 2 resets.
Mr. Rodwald, do you wish to respond also?
Yeah, I guess my concern is that it is a complex case. To me, there are some sort of contradictory issues here that need to be vetted, and to the I think we were potentially punishing the wrong person because he can't change lawyers with a week or two's notice. And he was counting on having counsel to help him here with things like exhibits that of course he probably doesn't know. That's my concern.
Correct.
Mr. Chair, can I ask, you have witnesses?
No, I don't.
Okay. The detective,
He's a resource witness if you have questions about his investigation.
so he drove up from San Antonio this morning?
Yes, he drove up for San Antonio this morning, and the reason the subpoena was issued for today's hearing was based on the letter that Mr. Frischi had issued. I mean, at some point, I have to be able to rely upon what opposing counsel tells me is good for their schedule.
Commission, I pray that you understand where I'm coming from. A couple of things. Number one, we're at the taxpayer's expense here to deliberate on this case. This case was advertised. The attorney had provided us the information when they were available. It's unfortunate that the attorney is not here. I believe that the information that's been provided by staff is appropriate, explains the details of the case. And I do understand that there may be some questions that you may have that are unanswerable, but I really believe that this needs to be heard today. Now, the other cases that were cited, my memory fails me, but I do recall that there were items in those cases where, I don't remember all the details, but there were circumstances which prevailed us to go back in and postpone the case hearing. So, but in this one, I don't see any prevailing reasons why we should postpone this case.
Commissioners, if I may.
Well, just say, if Commissioner Yurko or Rodwald would want to push forward a motion to reconsider, we can take that up at this time and let the commission decide on how they want to handle that, so.
Okay, I'll do a motion to reconsider the continuance.
I would second that.
We have a motion and a second to reconsider. All in favor signify by saying aye.
Aye.
Those opposed? No.
Nay.
Ms. Mahon, again, would you call roll on this?
Yes, sir. Tom Butler,
Nay.
Helen Collier,
No.
Rick Figueroa,
No.
Catherine Roadwall,
Yes.
Robbie Shaw,
No.
Deborah Yurko,
Aye.
Mike Mendez.
No. Motion fails 2-5. We'll continue on. Mr. Venegas, go ahead.
Once again, this specific property is not a patrol property, which basically means that the property doesn't allow us to enter the facility without their consent. This vehicle was called in by a supervising maintenance, and because they had been specifically warned that they cannot bring their purchased auction vehicles to that facility. We have released 2 vehicles in the past from this specific same owner at courtesy, and we were forced to release the 3rd vehicle by the city of San Antonio, and now we are here. So they were fully aware that they were not authorized to operate a business or store vehicles on that property. It also states it on the signs that vehicles that are inoperable, and on the lease that they must register these vehicles to the community. This vehicle is not, and many others that they own were not registered to this community.
What is your understanding of storing as it relates to the property? How do they define store if it's just kept overnight?
The problem is that it's not kept overnight, Commissioner, and
But what we have here is that they came home from work in this vehicle, and then she went out later to grab some stuff out of there, and the vehicle's gone.
Commissioner.
So, I mean, do you classify that as store?
Absolutely not. But the documentation that they provided the city of San Antonio was handwritten by the people that they purchased or they conduct business with. They wrote the actual incorrect dates purposely so that they can protect the person that's buying the vehicles from them.
And that was proven in the investigation that they wrote the dates incorrectly? Or is that your assumption?
That is not an assumption. That is the truth.
So that was found in the investigation that they were doctoring the documents?
That was not brought up in the actual case hearing.
So I go back to that's your assumption.
I suppose that is my assumption.
Again, I want to go back to the question is the investigation that was held showed that the vehicle was brought in that I guess, late afternoon, evening by a employee of Thunderbird Motors. Is that correct? Is that what you got also?
The vehicle was called in at 2 o'clock in the afternoon. The vehicle wasn't picked up till about almost 8 o'clock at night.
Okay, so, but the person brought it in, they testified, and I guess the investigators showed the same thing, that they brought it in from work, and then she went out to get some stuff out of there. I mean, that's what I'm reading here, and that was, if I'm not mistaken, what was presented by the San Antonio Police Department.
If the vehicle was called in to be picked up from the property at 1 something in the afternoon, and we didn't pick it up till after 8 o'clock, the second ship came in, I'm not sure where they're driving the vehicle in. The vehicle had been parked there already a couple of days.
So I guess the property considered that to be storing.
The property considered actual notice given to the resident that they were not allowed to bring in vehicles that are not registered on their lease agreement. And once again, what they do is they
Got it.
buy vehicles and they take them to the
So
apartment.
they have to tell the property owner which vehicles they're driving and register it with the property.
They're
owner.
only authorized to register 2 vehicles according to the lease agreement.
Okay,
And
got it.
anything,
Thank you. Now, it answers my question, because the lease agreement basically said that they could not have more than 2 registered vehicles with the property, and you're telling me that this person was bringing in vehicles because they worked there and they would just drive them in and out. They would grab a vehicle and drive it in and out.
they would purchase them from the auction and they would bring sometimes 4, 5, sometimes 9 vehicles and
Object, Your
store them.
Honor. Mr. Chairman, there was no such evidence introduced at the contested case hearing about 4, 5, or 6 vehicles being left in the parking lot as an adjunct to the business operations of Thunderbird Motors.
Okay.
Haynes here, under the findings of fact number 16, it says residents are not required to register their vehicles. That's what the SOA judge found.
That's not part of the lease agreement. The actual contract specifically states to the leaseholder that they're not authorized to register, have more than 2 vehicles registered. I don't understand where the city of San Antonio can impede with a actual contractual agreement between the property owner and the leaseholder.
Mr. Shirk, I guess kind of going on Commissioner Butler's question, was there presentation in the SOA hearing about residents were not required to register the vehicles?
No, petitioner put on that evidence during its case in chief, and there was no contest to that evidence.
Oh, okay.
Mr. Chairman, it's Brad Bowman, General Counsel. I just wanted to, this just in, I have my staff has pulled the exhibit list from the SOA hearing. We don't have the actual exhibits, but the apartment lease contract was apparently one of respondents' exhibits, so I don't know exactly what that consisted of, but
So
it is
is
listed
that
on
was
there.
what you brought forward?
This is what I brought forward, and this is what Prosecutor Shirk
Mr. Bummer,
said
what
was
was the
not
exhibit
admitted.
number?
I would strongly plead
Number.
to the commission that the reason
Wait,
that,
can-
that
can we
hang on
hold
just a second.
just a
What
second,
number was that?
Mr. Venegas? It's, this is Brad Bowman again, it's number 5, apartment lease contract, and there's a note as to whether it was admitted or not, and it says, there's a Y that says, indicates it was admitted. So we may.
There may be
we
question.
may stand corrected on that.
Mr. Shirk, how do you handle that?
My exhibit list and certification from the SOA judge shows Exhibit 5 was a tow ticket. This is.
So we have conflicting
Well,
documents?
No, there's petitioner's exhibits, and that, I think that's what Michael's looking at, and then
On the back
on
side.
the back, there's the respondent's exhibit, so apparently, respondent offered that as an exhibit. And again, I don't know exactly what that exhibit consisted of, we don't have that available, but.
Well, this has become much
Com-
more
Commissioners,
complicated in that respect.
I will give up any argument that the lease was not in there. If Mr. Venegas wants to argue from it, I'm happy to have him argue from it. I don't have it in front of me, but I don't want to stand in his way.
That'd be, Well, I guess the question that I have now is, which I've now been swayed the other way, are we not allowing all the documents to be presented? And Mr. Venegas, from my understanding, has kind of been thrown into this.
I'm prepared to argue further why this continuance should not be allowed. I've also reconsidered, and if Mr. Venegas is saying that that was a document that was admitted in evidence, I'm prepared to admit that or agree with that. The document itself is irrelevant to the disposition of this case, and so whether it comes before you now or whether it was in front of the administrative law judge, it doesn't hurt my case. So if you take it up.
Well, let's go ahead and present it. You can go and present the contract.
I only have one copy.
That's fine. You can just kind of tell us what it says.
Okay. Basically, paragraph 21 specifically talks about the motor and modern way of operating the parking facility. That means that they cannot have any unauthorized vehicles that are not within the lease, the confines of the lease agreement. They signed it. They also printed the name, making them aware that any vehicle that they operated must be registered to the community. And after them being warned so many times, after the towing company returning vehicles at no cost, they thought enough was enough, and so did we. We weren't going to release a vehicle at no cost anymore until we were forced by the city of San Antonio to return it, or else I would be arrested. At that time, I had to make a decision. The last thing I wanted is for Ricardo to come out on the news or Atlas Towing to come out on the news. Auto theft towing company, and that's the last thing that we want.
Sure. Was there a document submitted to the SOA judge about the warnings?
Did
you submit that in as part of evidence?
Yes, I did. I submitted the letter of actual notice from the property manager, specifically informing Ms. Souza that they cannot bring any more vehicles to that property. Any other vehicle would be impounded. I also have a documentation given by Detective Mahalik, and if you would allow him to explain the city's interpretation of actual notice, because it was not admitted as in the case, if you would please ask him what the city stands in regards to actual notice. And you will see that the information that I have does comply and meet the requirements in accordance to actual notice, and we did have probable cause to remove that vehicle.
Okay, so there is documented proof that was submitted as evidence of warnings that was given to Ms. Sosa?
Correct. And there was 2 vehicles that had previously been released out of courtesy from the towing company, and because we wanted to maintain good faith with the community. So we took back 2 vehicles that belonged to her that she purchased at the auction. And then the third one, we just refused to, the towing company refused to return, and so did the property management. They no longer wanted to release that vehicle at no cost.
Okay. Questions? Mr. Venegas? Anything else, Mr. Venegas?
No, sir.
One question. Is
Yes.
that a standard Texas lease agreement?
Yes, it is. Texas Apartment
It
Association.
is the standard Texas Apartment
Yes, ma'am, it
Association
is.
lease agreement.
One of the things I wanted to mention is the main reason our fees have been substantially reduced is because the person who represents me, the attorney who represents me, is much better at explaining the process than I am.
You've done a good job. You have. You've done a good job.
I have a question.
Yes.
Commissioner Yurko, to the respondent. Did you all drive around and find the car, or did someone from the apartment complex call you to tow the car?
We were called in to pick up that specific vehicle by the maintenance supervisor. Our contract with that property does not allow us to drive around and pick up inoperable vehicles because we don't know which ones are inoperable. We don't know which ones are the ones that she drives or a specific person drives. The apartment, the community employees are the ones who are able to tell, okay, Miss Souza drove in this Maxima, Miss Souza drove in this other minivan, or whatever the situation is. The only thing we're allowed to patrol there is only city ordinance violations, which is handicaps, fire lanes, and vehicles left on jack stands.
Mr. Shaw?
Mr. Chair, I'm just going to make a comment and observation. You know, in my neighborhood, we have several car dealership owners, and I see them driving all different cars at all different times. And so I don't see anything different with this one individual driving in a vehicle. From what I read in the case report, That's their business, that's what they do. Unless the apartment required a specific decal or something like that on the vehicle, I could understand that better, but in this case, I can't. I mean, what vehicle they drive, what vehicle they bring in matters less.
Well, I understand that, but wouldn't that be the issue for the apartment company, not the towing person?
Yes.
He's being called by the apartment company to remove the car. So wouldn't the issue be between the apartment and their renters? I don't think it should be his problem. He was called by them and told to tow the car.
Thank you for that.
May I address
We're
that?
holding the wrong person responsible.
There's been a couple comments about maybe the wrong entity or person is in front of the commission at this point. The mere fact that a apartment complex owner or a commercial parking facility owner calls a tow company in does not indemnify or protect the tow company from making an illegal tow. The tow company must ascertain whether or not sufficient facts exist so that a tow complies with the language of the Tow Act. Otherwise, there would never be responsibility on tow companies. And don't forget, the state of Texas has vested tow companies with extraordinary power to seize private property and not return it until the storage and towing fees are paid. So the legislature properly put a responsibility on the tow company drivers. This is why, for goodness sakes, you require the drivers to go to training so that they know what the law is. To argue that a tow will never be held against a tow company simply because somebody called up and said, tow this car, would eviscerate the law.
Well, I understand, I agree with you, Mr. Shirk, that is true. But in this case, I'm trying to understand, was it just an average person that called and asked him to be towed? Or was it an agent of the apartment complex that called and asked him to tow a car?
I believe that was addressed in the findings of fact by the administrative law judge.
It was an agent of the complex.
Correct.
Yeah, it was an agent.
Right. So, to me, that distinguishes your argument a little bit, because it's not just, they did actually, you could argue, took the steps required by the statute because they were responding to a call by an agent of the apartment complex. They didn't respond to a tow by an average person flagging down to have a car towed. It was actually an agent of the apartment complex.
And it doesn't change my argument, because even if it is an agent, even if it's the owner of the apartment complex or of the, let's say, a parking, shopping mall or something like that, the tow company and the tow driver is still held accountable if a tow is performed illegally. Otherwise, we would never have, we should just abolish any liability on tow truck operators and tow companies. They're in the best position and should not be indemnified, protected, and let off the hook simply because they got a phone call from somebody and failed to investigate or comply with the law. And that's why our statute's written.
Mr. Shaw.
Just a quick question. Again, my memory fails me, but can you repeat again what you said about us hearing this case in January and reducing the fee down? Could you repeat that statement?
Yes. My argument was, or my presentation was about significant downward departures from the enforcement plan, which recognizes, of course, that you're not bound by the department's enforcement plan. In December 2014, PFD came before you that recommended an administrative penalty of $4,000 against respondent for 2 Class F violations. Commission review in March 2015, the penalty was reduced to $2,000, $1,000 for each penalty. In November 2015, another administrative law judge found 2 Class F violations and assessed $4,000, $2,000 for each penalty. When the proposal came before the commission on January 6th of this year, the penalty was reduced to a total of $500 for both violations. And in furtherance of my argument that an upward deviation is appropriate, the commission should bear note that agreed orders imposing sanctions were issued against the respondent on June 29th, 2011 in the amount of $2,000, and on September 11th, 2012 for $1,000. So this is not his first time before you, nor is it the first time we've tried deterrence. I'm also very much prepared to give you more information about why going forward in light of this request for continuance is absolutely just.
So all these cases you're referring to have to do with Atlas?
Yes.
Any other questions, Commissioner Butler?
I'd like to hear from the detective on what his investigation, his perspective is.
Remember, you have to stick to what you testified.
Detective, again, state your name for the record, but also, I'm sure you've probably been through this before, you can only be, bring forward to the commission that was presented at the SOA hearing. I'm assuming you were at the SOA hearing.
Yes, sir, I was.
Okay. If you don't mind, only present that information that was presented at the SOA hearing. Again, state your name for the record, please.
I am Detective Glenn Mahalik, and I am a detective with the San Antonio Police Department since 2012. I've been on the department since '98, so that's my term there. My assignment at the time that this happened was with the Wrecker Unit. I'm part of the Vehicle Crimes Unit. I'm currently in auto theft. I've actually moved as of January of this year. So at that time, I was actually investigating tow complaints that came in. I did handle the tow complaint from Ms. Sousa, who called it in, and conducted my investigation from there. She ended up filing the TDLR complaint and everything against Atlas Towing because of how it all went. It didn't go well for her, and through my investigation, which was already presented by Mr. Shirk, it's already been kind of addressed as to some of the things that were not consistent, is a nice way to put it, with the tow company versus the evidence that was found through the course of my investigation. A lot of the things that have been brought up today, I want to definitely address one thing. Mr. Venegas said that San Antonio, or City of San Antonio, or the police department forced them to return that vehicle. That did not happen. That did not happen. When I did my investigation, I gave him opportunity after opportunity after opportunity to provide the evidence that I was asking for, and he couldn't come up with it. On our last meeting, when I was actually at the tow facility, and I actually took the photos that y'all have before you in the exhibit, I was given the answer of, my computer's down, I can't get it for you. You're not going to believe me. But that's the truth. And that's what I was given at that last particular opportunity. Months went by during all of this to get this all done, and he was never able to provide me any of the things that he claimed that he could provide. It just didn't happen. So I wanted to make the record clear that he was not forced to return that vehicle. What he's probably referring to is whenever we reach that point in our conversation where I'm here on behalf of the citizen calling the complaint, I have a job to do. He told me, do my job, hung up the phone on me, which meant I was going to be forced to go forward with filing a theft of vehicle case because he had no probable cause for taking that vehicle from that property. I'll be glad to address any questions y'all have regarding that.
Any questions for Detective?
Yes, sir. Detective, I'd like to know a little bit about your initial contact with him. I think it was mentioned that something about a paint mark on the vehicle.
Yes, sir. In the conversation where the paint mark came up, I had been trying to get information from the tow company. It wasn't happening through the office manager, so I ended up speaking with Mr. Venegas personally. During that phone conversation, which is recorded, he did say that they had been watching that vehicle, that it had been abandoned there for 35 to 40 days, and that they had marked the tire, and they had provided notice to the person that it had to be removed. During the course of my investigation, of course, I obtained the photos that were from the driver himself, who actually went out and towed the vehicle, and the drivers showed all angles of the car, and there were no marked tires. Yet when I went to the vehicle storage facility, the tire's got a white mark on it. It's distinct. It stands out. You can't miss it. The other thing that stood out to me, too, was the 35 to 40 days. When I did the research, they only picked up the vehicle. I have a purchase order that backs that up, and this was brought up in that hearing with the ALJ, that it was picked up 3 days prior. So there's no way this could have applied to that vehicle. There was no notice given for that particular vehicle to be towed.
The purchase order was Exhibit 36.
So the pictures of the tire at the apartment complex were taken by the driver of Atlas Towing?
That is correct, sir. Taken by the driver who towed it.
And all angles of the vehicle. And as we have before us, there was no markings on there.
That is correct, sir.
And then when you went to the tow company, to the storage facility, there were markings on the tire.
That is correct, sir. Another thing I can add to that is with the driver, I interviewed him as well and spoke with him, and I asked him, why did he tow the vehicle? I have it right here in my notes. I could read it for you verbatim of what I wrote back on April 6, 2015, or I can just summarize.
Was it presented?
It
Was it
was,
presented?
these things were covered, yes.
At the SOA hearing?
Yes, sir.
If you don't mind, for me, for my sake, just summarize it.
That was not presented. If you can show me somewhere where it was presented.
That's okay, we don't need to go there.
We don't need to go there.
Conversation.
Okay.
I have a question.
Yes.
So do we know if anybody from the apartment complex ever called to have the vehicle towed?
Through my investigation, I spoke with 3 managers from there. All 3 stated they did not request a tow of the vehicle. All in recorded conversations.
I think it was a comment made by Mr. Venegas that the maintenance manager, did you,
I have no record of that. I asked for the information for that person. No one's ever given me a name from that company.
so
to
in
talk
your
to someone.
investigation, you had nothing?
Had nothing.
Okay.
No one asked for it. And in my talking to the driver gave me a different reason for the tow.
What was his reason?
Inoperable. He towed it because it was inoperable. I asked him to define inoperable. He said it had dust on it, which is that time of year when the oak trees have the green pollen that falls. He said that combined with the fact that it had no plate, so he ran the VIN number, found it wasn't registered to that address. So those are the reasons that he chose to tow it on a patrol, not on a management request.
Oh, so he says he did it on patrol?
Yes, sir.
So at this point, we have 3 different reasons for the tow.
Mr. Chair, are we going to move forward with an action, or, because it sounds like we're rehearing the case from my perspective. I know that I'm still new, but what are we doing here?
I think that we're currently asking questions to be able to get to a conclusion.
Okay.
Any other questions for Mr. Shirk or the detective? Mr. Venegas, is there anything that you want to be able to say?
Absolutely. Mr. Detective Glenn just said that I told him that the vehicle had been there for 34 or 40 days. That's totally incorrect. I told him that the vehicle had been there for 3 or 4 days, not 30 or 40 days. So where he's getting that information from is not from me.
Okay.
In addition to that, he was fully aware of an actual notice, and I would like for him to explain how the city of San Antonio interprets actual notice, because I'd like the commission to see that we met that criteria, the apartment community met that criteria, and that vehicle had probable cause to be removed. In addition, this specific person, let's just take this out of the box. Let's just say that just a regular person who doesn't live there had her vehicle impounded. Yes, I totally agree. I totally agree with the state's position that that vehicle did not merit to be impounded. But when the resident has been specifically told, has been given actual notice that if you bring any more vehicles to this community, your vehicles will be towed. The mark, the inoperable, those are also reasons that the vehicle was impounded. But actual notice was given to this specific resident that if they brought any more vehicles that were not registered on the lease agreement, they would be towed. Now, I'd like to go back as far as the fines. You made a question in regards to the findings in December. The fines were $4,000 because, once again, the ALG is confined to a specific amount of a violation. When it was brought up to the commission saw it fit that that punishment did not merit that fine. Now, I sat here earlier and we listened to horrible crimes that were being committed. The fines that we're talking about in the January case, in the December case, were one word. One word. The one word was unauthorized. Because the unauthorized was after abandoned, the state position was that it was an illegal sign. The verbiage was correct, and that's why the commission found it fit to not fine me $4,000. Mr. Shirk brings here a bonfire of violations, but it sounds horrible. It sounds like we shouldn't be in business. But when the commission really takes a look at it, at what's being presented, they always seem to reduce the fines. Why? Because it doesn't fit the violation. They're de minimis violations. As I mentioned earlier, I sat here and I listened to the sexual assaults, horrible crimes. The crimes that the violations that we are doing, they are not nowhere near those types of crimes. The person was given actual notice, and I like to see if he can. I have an actual email describing of what actual notice from Detective Glenn Mahalik. If the commission would please allow him to state the city's position of what he understands as, or what the city takes on actual notice definition of.
Well, I think that we're based on what state statute says. So, I'm sorry, but I think we have to go based on what the statute says. Anything else for Mr. Venegas?
Yes, I have one question. What is your response to the people at the apartment complex telling the detective that they didn't call for that tow?
I have been providing the towing service for the same management for 13 years, and I am still there. There's no trickery behind our game. We're not trying to fraud or anything. The response to the detective was that they authorized us to pick up that vehicle. Had we picked up a vehicle or shown up without authorization, the first thing the community would have done is get them off of my properties. That's the last thing. We still provide the service for them. In addition, we've added 6 more of their properties. There's no trickery behind our game, Detective Glenn.
That's not exactly my question. My question is that he talked with 3 people in management there, each of whom said they did not request that tow. So that's what I'm trying to understand, but yet you seem to think they did request the tow.
I don't seem to think, I am for sure that they requested this tow. And not only that, the detective spoke to the regional manager. The regional manager told them there's no wrongdoing that the community has done. There's no wrongdoing that the towing company has done. We requested this vehicle to be removed because we've already told the resident not to have these cars here. Was the vehicle on the the vehicle registered on their lease agreement? No. So that's why the vehicle was impounded. Once again, we are still in that community. We've not been fired from there.
Okay. Anything else for Mr. Venegas?
One more question. How much time does the apartment complex give an individual who does, in this case, living with their boyfriend or staying with their boyfriend, we're not sure, how much time does the apartment complex give them to register their car?
Commissioner Butler, that's a very good question, and this is exactly why I would like for the commission to allow Detective Glenn Mahalik what the city of San Antonio interprets actual notice. Once you understand...
I'm asking you on the lease. What does the apartment complex allow?
If you're not registered, you must be parked at least in a visitor parking area. If you're not registered, they find out if you're an unauthorized occupant, they put a sticker on your vehicle, and it's either a 48 to a 72 hour, depending on which apartment and which lease it is.
Okay. Anything else for Mr. Venegas? Thank you, sir. Any questions for Mr. Shirk? Mr. Shirk? Is there anything else that let's
I will
make it quick
wrap
here.
this up. I would like to bring this back to the factual findings of the administrative law judge rather than having this quasi-testimony given. On page 10, finding of fact number 17, the administrative law judge found specifically that Ms. Sosa parked a vehicle in a non-reserved parking space. 18 found that she had driven the vehicle home from work. It was not parked at the apartment complex during the day. Going into the administrative law judge's discussion on page 7, and I'll read it from the proposal for decision based on the evidence that the administrative law judge found. Quote, Officer Mahalik went to the apartment complex on April 2nd, 2015. Exhibit 33 is a diagram he drew of the complex. He spoke with the Lakeside Villa Apartments manager, assistant manager, and regional manager, none of whom said they had requested the tow. However, the assistant manager said respondent was allowed to patrol the parking lot and pick up vehicles. Allowed to patrol and pick up vehicles. That's what the administrative law judge said. We don't have the time to re-argue it. The facts are very clear as found by the administrative law judge. The evidence is clear. The administrative law judge also found in her proposal for decision that no notice was given to Ms. Sosa. We can't re-argue that. Given respondent's history, given the mendacity in this case, and given the need to deter future conduct, it is staff's request that you make an upward departure from the penalty matrix in this case. Adopt PFD as written, but impose or assess a sanction in excess of $2,000. Thank you.
Thank you, Mr. Shirk. Final
Final closing is, please keep in mind that the vehicle that belonged, the vehicles that were operated by Ms. Souza had been previously released. She had warning. She had actual notice. The actual notice specifically given to her was that we're going to give these 2 vehicles back. Anything else we're not returning. There is no violation in part of the towing company. There's no violation that we can find that was done by the apartment community.
Okay.
And that is my closing.
Thank you. You can have a seat. Appreciate it. Detective, thank you.
Thank you, sir.
Commissioners, discussion or motion to be in order? The PFD before us is a penalty of $2,000 against the respondent for Class F first-time violations.
Mr. Chairman, I'm not prepared to make a motion, but I will.
We have a motion.
Oh, we do have a motion.
Go ahead.
We have a motion.
Second.
A second. Discussion? Did you have something you wanted to add?
Yeah, discussion. I was just gonna add that, and I can understand how some of the commission here may feel that there's a,
It doesn't matter. It's up to you.
the commission may feel that there may be a need for continuation or something else in here, but I do want to make a statement in here that may be a lot of hearsay, but I do have to say that as a motion's made, I will vote towards the fact that the only thing we can rely on is the PFD. And that's all we can rely on, because it seems like there's a lot of hearsay, and rather than getting into all the he said, she said business, maybe we focus more on the PFD. So I'll kind of step back and let the motion ride.
We have a motion on the floor. All in favor signify by saying aye.
Wait.
Oh, I'm sorry.
I had one other, I thought we were gonna still.
Oh, I'm sorry.
comments.
Go right ahead.
Okay.
Yes, my
You know,
apologies.
I still think that we should have, waited for council, because I think we heard a bunch of stuff that didn't make sense, and I don't feel like we really got a chance to hear this case evenly, because things were said that we're told they weren't in record, then they were in record, and maybe they weren't in record. I still don't have a clear answer of what we should have actually been hearing, whether we heard more than we were supposed to hear. That being said, I'm gonna go along with the vote. I still have a question as to who was the one who was authorized to call this tow company, and in that case, even if you find that they should not have towed it, I still find the amount to be egregiously high at $2,000.
Any other comments? All those in favor of the motion to adopt the PFD, signify by saying aye.
Mr. Chair, before you go there.
Oh, I'm glad you mentioned that. There is a technical correction. If the motion maker would amend to
correction.
simply the
Include
correction.
that technical correction.
And the second, would accept that also?
That's you.
Did I make the motion?
No,
Oh,
I made
you
the
want to say
motion.
second?
Yes, I will
Yes.
second.
So, yes.
Just further discussion on that motion, would the motion maker include the penalty in there as well, so that it is clear on record?
To accept the PFD as said. It
Which is
includes that,
$2,000.
it includes that pay. penalty.
Okay. All in favor signify by saying aye.
Aye.
Those opposed?
No.
We have 5-2, motion carries. Mr. Venegas?
Yes, sir.
We adopted the PFD. There are other administrative remedies that you can get with the council, with our staff, I'm sorry. And they'll tell you what your next options are. There are still administrative remedies for you, okay? And I'm sure your attorney would know what those are.
Well, thank you,
All right.
and once again, thank you, and I apologize for not knowing the ethics.
No, you did well, thank you. Appreciate it. Let's move on to item G3, which is Cecilia Chavez. Mr. Sharp.
Morning, Mr. Chairman, Commissioners.
Morning.
See, I've got the last case here, and I promise it won't be nearly as exciting. The respondent in this case is Cecilia Chavez, and she's licensed as a vehicle storage facility employee. The administrative law judge recommends the revocation of that license. Ms. Chavez was first licensed as a vehicle storage facility employee, or VSF employee, on November 19th of 2014. And her VSF employee license was good for 1 year. It was effective for a year. A little over 3 months after she was licensed, she pled guilty to the charge of manufacture or delivery of a controlled substance and was placed on deferred adjudication community supervision. And that charge arose when police officers who were working in an area of high volume drug trafficking and they had stopped the respondent and discovered cocaine in her possession. They arrested her for the cocaine, and they took her to jail, and at the jail, the corrections officer found a plastic bag containing a large amount of crack cocaine hidden in the respondent's underwear. That bag contained 73 times the normal usable amount of cocaine, which is about 73 doses is what it would come to. And the evidence at the hearing showed that that's consistent with drug trafficking. On October 15th of 2015, just about 8 months after she was placed on deferred adjudication, the respondent applied to renew her VSF employee license. A question on the renewal application asked if she'd been placed on deferred adjudication since her most recent license was issued. And in spite of the court's order, the respondent answered no to that question. Well, the ALJ found the respondent currently lacks the honesty, trustworthiness, and integrity necessary to hold the license issued by the department. The ALJ also recognized, as the Commission did in its guidelines, that VSF employees would have the opportunity to repeat this type of crime. Under the guidelines, this offense is directly related to the occupation of a VSF employee. The ALJ recommends that you revoke the respondent's vehicle storage facility license, or employee license, and the department asks that you adopt that PFD as written. Thank you.
Any questions for Mr. Sharp? Motion, is Ms. Chavez in the audience? Representative? Commissioners, a motion be in order?
I move to adopt as written.
I second it.
We have a motion and second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Let's move on to the motions for rehearing. Joshua Boyd.
Commissioners, Doug Jennings is going to present the motions for rehearing
Jennings.
this time.
Morning, Commissioners. Della Lindquist will not be performing motions for rehearing. She's at a conference today, so I will be taking over in her stead.
Right ahead.
The first matter for motion for rehearing is TDLR v. Joshua R. Boyd. And this matter resulted from a default order. The respondent was served with an NOAV, opted not to respond, did not request a hearing. The executive director assessed a $3,500 administrative penalty against the respondent for offering to perform electrical contracting work without a license. The respondent's motion for rehearing didn't allege any error on the department's part, merely stated that he believed he was acting pursuant to a license that was supposedly lent to him by a friend. Electrical licenses are not transferable. It says so in the statute. And so that was really his only claim. Didn't claim that there was an issue with service or identify any error in particular. So the General Counsel is recommending a denial of that motion.
Is anybody here on behalf of Mr. Boyd? Chair will entertain a motion. Come. Any questions, comments?
So moved.
Second.
Moved and seconded. All those in favor signify by saying aye.
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 Those no. The motion carries. The next item for discussion is a case involving Quincy Johnson.
Yes, Vice Chairman.
Is anybody representing Mr. Johnson here? Okay, please proceed.
All right, thank you. This is another matter resulting from a default order. In this case, the respondent was served with an NOAV, requested a hearing, but later did not attend the hearing. Also provided no justification either to our department, to enforcement, didn't call GC, and also didn't contact SOA to attempt to extend deadlines or revive the matter. So a default order was issued by the executive director assessing a $5,000 administrative penalty against the respondent. This again was an unlicensed electrical activity case. And if we have any factual questions, Trevor Thielen from our enforcement division is here to answer any questions about the facts of the case. The respondent's motion for rehearing really centered upon his argument. The only argument he really provided was the "it wasn't me" defense. And we, looking through the materials put together by our investigators, believe that it absolutely was the respondent engaging in this unlicensed activity. An analysis of the phone numbers and of the names used in the advertisements, and also admitted his identity. He went under a pseudonym in conversations with our investigators on the phone, and then through some further questioning by the investigator, admitted that he was in fact Quincy Johnson. We believe it's very clear that the respondent was engaged in the alleged violations here. And if you have further questions, I would defer to Mr. Thielen.
Members of the commission, is there any questions for council? Any discussion? Entertain a motion.
So moved.
We have a motion, second. We have a motion and second. All those in favor, please signify by saying aye.
Aye.
Those opposed, say no. The motion carries. Thank you.
Thank you.
We'll now move on to item I, which is the discussion, proposed amendments for continuing education requirements. Who's presenting that?
Colleen Tran will be
Come on up, Colin.
presenting that item.
Morning. So we tag teaming this?
Yes.
Go right ahead.
Good morning, Commissioner, Mr. Chairman, Commissioners. My name is Colleen Tran. I'm Assistant General Counsel. And I have Ray with me.
Ray Pizarro, Director for the Education Examination Division.
We're here to discuss, Colleen Tran again, we're here to discuss and walk you through the adoption of proposed amendments to 16 Texas Administrative Code, Chapter 59, Continuing Education Requirements. The proposed amendments update the list of professions that are required to complete continuing education. They allow the department to streamline continuing education requirements across the several programs that require CE, continuing education. They provide the department with better enforcement tools to hold the continuing education providers accountable to the consumers that they serve. And they clean up expired language and make editorial corrections to the renumbered sections. The proposed new rules were published in the Texas Register on May 27th, 2016. The public comment period closed on June 27th, 2016. And during the 30-day public comment period, the department received comments from 12 interested parties and made one change to Section 59.3 of the proposed rules based on one of the received comments. That particular comment wanted to know whether and how the rules would change the Property Tax Professions Program, the PTP program. Specifically, would the continuing education providers be required to now pay a registration fee, and would this inclusion conflict with the current PTP statute? While the answer to both of those questions was no, PTP would not have been required to change how they currently administer their program, because continuing education for the PTP program is unique in how it's administered, because statutorily it's administered with the assistance of the controller's office, so that controls how they do CE. But to eliminate any of the confusion with the inclusion, the departments decided to remove PTP from this rule proposal. So there being no other changes, we recommend the adoption of proposed amendments with the change to Section 59.3 and an effective date of October 1st, 2016. And both Ray and I are here to answer questions if you guys have any.
Any question for Ray or Colleen? A motion would be in order. This is to adopt effective October 1.
October 1, 2016.
Mr. Chairman, so moved.
We have a motion.
Second.
Second, all in favor signify by saying aye.
Aye.
Those opposed, motion carries. My item J, which is the procedural rules. Mr. Bowman.
Mr. Chairman, Commissioners, I'm Brad Bowman, General Counsel. This item is an amendment to Chapter 60, which are the procedural rules of the Commission and the Department. These are the general rules that apply to all of the Department's regulated programs. And this is an amendment simply to update the list of advisory boards for the Department's programs with the new boards for the new health-related programs that are transferring over, and also the Combative Sports Advisory Board, which the name of that and the composition of that board changed from the last legislative session. So this is a kind of technical updates to that section. And the reason for having that section in the first place, just by way of background, Chapter 2110 of the Government Code is a general provision that applies to all state agency advisory committees. And one of the requirements there is to have an abolishment date for advisory committees. Sort of like a sunset date, and forces the agency to reevaluate periodically whether these committees are still needed. In our situation, these advisory boards are set up by statute, so it's most likely that these would all be continued once we get close to that abolishment date, but that's something we'd address at that time. We did receive one public comment. It was asking about the, in particular about the athletic trainer advisory board, and just, what happens if we abolish the board. And again, the intent is not to actually abolish the board as long as there is a statutory authorization and reason for having that board. One technical change on number 19, the speech language pathologist and audiologists, the words advisory board should be added in there. So that was an oversight, but technical correction for you there. So we would recommend adoption of the rule with that correction with an effective date of October 1st, 2016. And I'm available to answer any questions.
Any questions for Brad? A motion be in order?
Commission in the department.
We have a motion on the floor. I'm trying to stall to get a second.
Second.
Second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item K, rules for the height requirements for IHB. Mr. Johnson, you doing that one? We're playing musical chairs today, guys.
Commissioners, for the records, Charles Johnson, Assistant General Counsel. You have in front of you a non-controversial amendment to Chapter 70 of the Administrative Code. This amendment changes the height requirements for industrialized housing from the existing height requirement is 3 stories. This changes it to 4. The height requirement goes from 49 to 60 as a result of the implementation of Senate Bill 1264. We're asking, the rule was published in the Texas Register. We received no comments, and so we're asking you to adopt the rule with an effective date of October 1st, 2016.
Any questions for Mr. Johnson? Motion to be in order?
So moved, sir.
We have a motion?
Seconded.
Second. All in favor signify by saying aye.
Aye.
Those opposed, motion carries. Item L, possible action readoption of the 4-year review of the dog and cat breeders.
Yes, sir. Again, Charles Johnson, Assistant General Counsel. This is a 4-year rule review for Chapter 91 of the 16 TAC. As you are aware, the statute requires the rules be reviewed once every 4 years, and we're now at the 4-year period. They were published in the Texas Register, and we received substantial comment, in excess of 1,000 comments. However, those comments went to not the purpose of the rule review. The purpose of the rule review is to determine whether or not the initial rationale for adopting the rules still apply. And clearly, the rationale of the rules is still necessary because the comments are addressing potential changes to those rules. And those changes go to a couple of areas. The crate size, cage size, and housing, the environmental housing conditions for the animals. And so the way we intend to do the rule review is to first re-adopt the rules as we recommend you do. And then these comments will be sent to the advisory board, and the advisory board will go through each of those comments, determine which ones have merit, and recommend changes if necessary, bring back to you in a subsequent rulemaking. And so this process we're going through today does not address the merits of the comments. They'll be addressed separately. And I want to make that clear for the record so that all parties are aware that these comments that we have received so far will be addressed, just not at this point in time.
Okay, now, this is Commissioner Yurko, and I'm going to
Yes.
bring it up at this point, and you know what I'm going to bring up.
Yes.
And I want to say that because I think 1, 2, 3, all 5 of you were not present when these were adopted. And there was a big issue during the adoption of these rules, and it would not have passed but for my vote. And I switched my vote under the promise that we would address the crate and cage issue. And I have asked it repeatedly over the years to have that addressed. And now we're at 4 years, and it has never once been addressed. And Commissioner Morgan, before she left,
Discussed it also.
had discussed it also. And it was a repeated issue over and over, and we were assured we had to pass these rules to at least get rules on the board, and we were assured that we would address it right away. And I've got to be honest, I'm going to plead with all of you all not to vote for this, because it has never once been addressed in the 4 years. And I'm concerned that with all those comments, that you say that we're going to address it and that that's the way to do it. It was not done for 4 consecutive years.
If I may, there's a board meeting set next month, September 26th, I believe, where these comments will be presented to the board at that meeting for their consideration. And I think that the
And what board meeting is that?
the board meeting
Licensed
for the
breeders.
licensed breeders board, advisory board.
Thanks.
One of the rationales, I guess, for the rules have not been changed so far is that a decision was made at some point to see what was, to let the rules run a course before we sort of change courses. And I think we're at that point now where the concerns, the enforcement has been done. We now have a record of the conditions that exist in the industry, whereas before there was not. And so with the existing information we have about the program, we're now in a better position to assess the merits of the changes.
Okay, well, let me correct you on that, because what happened was at the rules, they demonstrated that they had a wonderful visual. I wish you all could have seen it. There was a wonderful visual demonstration of the cage sizes and how inhumane it was. But the rationale was we wanted to get rules on the books, and we were adopting the national guidelines. Doesn't necessarily mean it was the best guidelines, it was just the minimal requirements. And so it was encouraged that if we would just get the rules on, we would address the cage issue right away.
And that was 4 years ago.
4 years ago, which has never been brought up one time. Commissioner Morgan was the liaison for that board. She tried to get it addressed. I have insisted on it every time breeders has come up on any issue. It has never been addressed. And and 1,100 comments, when do you ever see 1,100 comments from the constituents?
What's your pleasure here? What would you like to do?
I would like to continue this until after the advisory board actually meets next time. And then we can readdress this then. I can't, in good conscience, vote for this because it's never been addressed in 4 years.
And I have a statement and actually a question. First of all, while I may not necessarily be on board with changing the rules as it relates to what Commissioner Yurko was talking about, I would agree with her that it was discussed then that the rules would be addressed at a later point, and she's absolutely correct. They have never been addressed. And even though I know, because Commissioner Morgan mentioned it to me, Commissioner Yurko's mentioned it to me, and this has been going on for probably at least 3 years that I know of, and it's never been addressed. So I would concur with what she's saying, is that has never taken place. Even though there was an assurance given to her and Commissioner Morgan, former Commissioner Morgan, that it would, it's never taken place.
4 our votes.
Yeah.
We would not have given the vote that day.
Now, the question I have is,
Mr.
what
Chairman,
happens if we
Mr.
do
Chairman.
not adopt these rules?
Please identify who made the assurance, though. It was the chair made the assurance.
No, actually, it was you, Mr. Kuntz.
It was a chair that agreed to it that day.
I'm sorry.
It was a chair that agreed to it that day in order to get the votes, but I know that there's been numerous discussions that were held that Commissioner Morgan said she visited with you. I know that Commissioner Yurko's visited with you. Now, Commissioner Denton is gone, and I've been in this position now for, 2 years, and I can tell you my failure to even address it is, I don't think we've ever talked, we may have discussed it briefly, but, now back to the question is,
If I may procedurally,
what happens if we don't adopt
Charles,
the rules?
let me interject. Let me interject here. Mr. Chairman, we're okay with holding off on a commission vote today. We normally try to kind of hit our 4-year marks, so procedurally, we're meeting our APA requirement, but we can hold off until
Okay.
a later meeting if the commission, if that's the will of the commission, so we can see how these issues
Commissioners, is
move
there
forward at the
any,
advisory board level.
is there any reservation to holding off on this until after the advisory board meeting of the licensed breeders? I want to hear from if there's any reservation.
Chairman, I'm new to this, right? So what's the delay?
As Mr. Bowman indicated, there's nothing that prevents you from delaying this. But what I would like to let the record accurately reflect is that to delay it to the next board meeting of the advisory board is not a resolution, because the next meeting of the board, of the advisory board, will be for the purpose of considering the comments, to take discussion, to go through the rulemaking process. And so until they actually come up with a proposed rule, which then gets published, we're looking December and January. And so.
And they could propose a rule at that meeting.
Yes. I just want the record to show that at the next board meeting, there will not be a proposed rule. And that the process will run, and it'll take months in order to get your rule back. So I don't want expectations to be that after the board meeting in September, that there'll be a rule.
Now, let me ask you, will that actually go past the date that we need?
Yes.
So what happens if it go past the date that we need?
No one's gonna come and arrest anybody.
We just get a bad grade on our report card for not having.
I don't think
It
you
could
answered
be
my
an
question,
audit
sir.
issue or something like that.
I'm a very simple-minded
Okay.
guy. This, apparently Commissioner Yurko's telling us 4 years, but this has been discussed. What is the delay? I don't want to know why hasn't this been addressed? What's the problem?
Why has Commissioner Yurko's concerns not been addressed in 4 years?
There are I guess a host of reasoning that I wouldn't want to identify one particular thing, but I go back to what I said earlier, is that as in all new programs, there's the general proposition that before you go ahead and change the initial rules, that you see how the program runs, you see what the problems are, and then you bring that data to the table in your next process.
But to that end, there's 1,100 comments. I think there's pretty good evidence that this is not going to run well.
Well, actually,
But I guess is it that you don't feel like you have enough data to support the change, or that you don't feel like you understand the issue clear enough?
I think it was a data up to this point.
I'm sorry?
Data up to this point. I think that there's enough data about the program now that it is running. It was a brand new program initially. I think there's enough data that's been accumulated to draw conclusions from. And so that's why we're proposing now to move forward with the comments being presented to the board at the next meeting.
So it takes 4 years to collect that data?
If you look at the population size, we're talking several hundred breeders. We're not talking thousands and thousands of data points.
But you are talking about 1,000 comments.
Well, actually, to clarify that, there are 1,000 submitters. But as in the initial program, there was one form letter prepared that was sent in by thousands of 1,000 people. So it's the exact same comment, the exact same complaint, just multiple repetitions of it.
I would tell you that if this comes back up, I'm going to have to hit hard questions about this issue. So I would submit to you, unless you're prepared to answer with complete clarity and facts to address the concerns that are in there, I would probably be hesitant to bring this back up because we're going to come back in the same circle again. That's just my comment.
The meeting is set, the die is cast, and we're ready to move forward.
Commissioner Shaw?
Just for the sake of clarity and moving forward, a couple of comments. The issue of the response of what happened when it was brought up 4 years ago and what has happened now, I think we can deal with that separately. I think in front of us, we have the rules today, and I think we need to deliberate on that. Whether we postpone making a motion on it or pass it on to the board and have that come back again, I don't have a problem with that. As long as we're not going to jail and we can work through the system here properly, I think I'm okay with that.
Commissioner,
Yeah, I guess when Brian made a comment about a report card, I'm not familiar with the report card and what all impact that has, no clue. And just to clarify again, what will the vote consist of? What are we voting on? To take the same rules and let them roll?
Yes.
Basically, yes. Now, it's kind of a clarification because I don't want to keep on going with this, but it's to simply continue with the rules as is, but there's some issues with the rules as it relates to the cage size and
I'm clear
stacking
on
and all
that- I'm
that.
clear on that piece.
And that would be basically adopting that all over again. So I can tell you that there have been some issues. You know, I take exception to the fact that we were collecting data. I think that we just kind of kept kicking the can down the road. But I think that in my opinion, if this is not addressed by the licensed breeders, then you'll see it on the agenda, because I think that Commissioner Yurko wants to be heard and she needs to be heard. And so if it's not addressed by the licensed breeders, you'll see it on the agenda for the commissioners to consider, and we'll just pass the rule ourselves.
Is that an option? Can we just pass the rule ourselves for the cage size?
We can.
We can?
I can tell you that we would want to probably get information from the licensed breeders, but because they simply make recommendations to us and we adopt the rules.
Well, wait, this is a wonderful twist, because I've never been told this. So if that's the situation, if it's not going to be addressed with a proposed thing by the next advisory board, what type of notice do you need so this is going to get adopted in the deal?
We would have to, Commissioners, as Brad Bowman, General Counsel, we would have to publish a notice. We'd have to start the rulemaking process, essentially. Publish a notice in the Texas Register, here are the proposed changes regarding cage sizes and
let
all
the
those
citizens
issues.
comment on those changes.
We'll get, open that for a 30-day public comment period, and then the commission could adopt that at the end of the comment period.
Okay.
So you can't make.
So are you saying we need 30 days notice?
That's the comment period. That it actually takes a lot more time than that, because we have to prepare the documents, file them, and so on. So
Okay,
it's
when's the deadline on this one? The absolute deadline, the drop-dead deadline for you?
I don't have that date handy.
Statute requires that every 4 years we do this rule review.
Right, when's the
Now,
when's the end of the 4 years?
We're trying to get that
Okay.
for you.
But as Brian said, there's no penalty for not doing it. TDLR has tried to follow the statutory directives and be on time with all of the things that we need to file. So that's the issue there. We can be late with that, that's fine.
Okay, but I still want to
I
find
speak
out.
that with 5 days left.
There's an underlying issue that perturbs me a little bit, and that's nobody's listened to Commissioner Yurko.
Or Morgan.
Or Morgan. And I know, this issue predates me, but I've heard you mention it a couple of times, and the same thing, that you were promised that changes would be made. And so I know you brought it up in commission meetings a couple of times, and it seems like nobody's paid attention to you. That bothers me a lot. And so that seems to be the disconnect.
Well, and
which
I
is
would,
concerning.
yeah, I would propose that, and tell me what the
And
commissioners
I
think,
don't
is that.
know anything about the issue.
Yeah.
I'm not pro or con.
Yeah.
I'm pro Yurka.
I can tell you my opinion that we not vote on these rules. We push it back down to the licensed breeder advisory board, let them listen to it. And it's sent, again, we'll be looking for the agenda coming out with the licensed breeders, and we're hoping it's on there, they take it up and consider this. Now, the recommendations they bring back to us, we still have to adopt it. Again, as I mentioned, I'm not opposed to the way the rules currently are set. I know some commissioners are, and as you said, they need to be heard. So I would suggest that we hold off on voting on this. Let's wait till we get to the licensed breeder advisory board, put it on their agenda, ask them to be able to consider this and take some testimony on this, and then bring it back to us. We'll be late. We know we're going to be late, but like I said, we're not.
And Mr. Chairman, really, we're talking about two different processes. The rule review just says, have you taken a look at what's there? And what we're talking about is, are you looking at moving forward with the new rule adoption and having a discussion? So that at the meeting on the 26th, on their agenda, they will have all the comments before them. People will have an opportunity to testify and make their voices heard. I know that Commissioner Yurko is one of the liaisons for the licensed breeder meeting, so she'll have an opportunity to be there and really listen firsthand to the dialogue. And then from there, there's several options. They may decide and say, with the data that's available, no change. Or they may say, oh my gosh, we need to do a rulemaking that extends the size of the crates, and then we'll move from there to do, a rulemaking process or not, based on that. But having that forum on the 26th is the proper way to go about this, and it's going to happen. The meeting's set, it's going to take place, and bring a sack lunch, because it's going to be a long day.
Well, the reason I have a question on it is because, and unfortunately, I will not be even in the state next week. Now, if we can do another.
It's September 26th.
Oh,
September 26th.
I thought you said it was next week. Okay.
September.
Okay. I have asked this to be on their agenda every time we've talked. Has it ever been put on their agenda?
Not to my knowledge, that's not. But it's gonna be on there now, and there's gonna be a full discussion about it.
Just for clarification, if the board comes back with a recommendation or does not even deliberate on that item, does the commission have then the wherewithal to make a recommendation? And then does the commission have the science behind what size those cages have to be able to make the recommendation? So I beg again that question, are we equipped to, and I again ask this commission, are you guys ready to come up with a dimension for those cages? Or should we maybe instruct the licensed breeders board, go back in and deliberate this, and maybe we give a directive?
And that's exactly what I think we need to do. We need to instruct them to take it up and consider that, and then with the help of staff, to be able to consider what those size cages would be. All of those issues that are at hand, let them discuss it there. Now, it could possibly be that the licensed breeders do not bring forward a rule. Okay, so if they do not, then it's at the prerogative and the discretion of this commission to propose a rule forward, which we still have to put out for Texas Register, go through that whole process again. But yes, it is possible for the commission still to try and put forth a rule that would be considered, so.
Great.
Commissioner, if I may, just again, for purposes of reasonable expectations, the way an issue of this complexity is resolved through other programs, through other boards, is that the first board meeting, and I anticipate the one on September 26th or 27th, will not be one where there are decisions being made, but rather work groups established, discussion had, those work groups then kind of get together and propose rules, which we bring back to the board for a second time in order to actually get a rule drafted and published.
Right, and
So,
while I
again-
agree to that extent, I think that the licensed breeders would be equipped once that meeting starts. Because I'm sure they're probably hearing it, I'm sure there's probably people out with the ASPCA saying, hey, let's gear up for September 26th, 27th, we're gonna be talking about this. And so I anticipate that they could potentially bring a rule forward at that point in time. I mean, it's just simply modifying the rule that is currently there is what they're gonna do.
Absolutely.
And again, my point of reference being the initial rulemaking, which was a substantial, lot of information, a lot of discussion taking place, and they were not able to resolve it. So I didn't anticipate that it would be simple in the next session.
Commissioner Robles.
I just have maybe a general suggestion for the executive office is that maybe you maintain a log of open issues for commissioners, because there's Deborah's issue, there was my issue that I was promised an answer on 3 or 4 months ago on commercial versus residential licensing and the cost of doing that, and I've never gotten an answer. And I know of at least one other commissioner who has an issue that's been hanging out there for over a year. So, I mean, maybe we just need to do a better job of tracking all these open issues, or else, I wonder why I come down here every month.
I agree.
If it's just academic.
I agree. Any other comments? So commissioners, at this point in time, are you inclined to adopt these rules, or are you inclined to simply hold off?
I'm going to move to continue
Okay.
this discussion.
I think I'm gonna agree with Deborah on that. I think we need to continue this, but also keep in mind that as we make a motion, if there's a motion required, that we pass a directive to the breeders board and ask them to consider these issues.
So we have a motion and second to continue this to a future meeting. And there's really no date certain because it's going to depend on information that we receive back.
Correct.
And
So,
Brian, could you please forward me the contact information for the people on the board?
Absolutely.
Thank you.
Was that a formal motion?
yes, it was.
Okay,
Formal
good.
motion. So all in favor signify by saying aye.
Aye.
Those opposed? Motion carries. We will continue this at a future meeting.
And once again, Commissioners, the sole purpose of the meeting next month is to resolve these issues.
Thank you.
Thank you.
Thank you.
You'll not be back again with a excuse.
I guess we addressed some of those issues though, didn't we? We have a mass exodus of people going out now. Let's go on to item N. Thank you for taking the time to show up. We appreciate it. Let's go on to item N, discussion possible action on agency recruitment plan. Is that going to be brought forth by Sharon?
No, I'll take care of that,
Okay.
Mr. Chairman. Bill Koontz, the Executive Director. This is one of those statutory requirements that we do, that, and it says that a recruitment plan, it's based on a workforce availability analysis, that each state agency shall develop and implement a plan to recruit qualified African Americans, Hispanic Americans, and females. The plan must comply with this chapter. The Commission shall monitor the state agency to determine compliance with this section. At the June meeting, Sharon had the Human Resources Office had the second quarter statistics according to this plan that showed the grievances, the number of vacancies, the number of hired, the employees promoted, the employees terminated, and the workforce composition. Additionally, you've got that in the strategic plan that on page 30 of the addendum that talks about the organizational profile of TDLR. We've historically had a very diverse workforce, and we've really had a good adherence to the ideal of equal hiring. So what we have is some tweaks that were done for our plan, so that, and that plan is there before you, so that we could send that to you for your review and concurrence.
Commissioners, any questions on the recruitment plan? A motion to be in order? I guess, it's a motion in order to adopt the recruitment plan as presented to us.
So moved.
We have a motion?
Second.
Second, all in favor signify by saying aye. Aye. Those opposed, motion carries. Let's move on to our staff reports.
Mr. Chairman, I'm sorry to interrupt, this is Brad Bowman. Did you want to cover item M today, or do you?
Oh, I'm
that
sorry,
for,
yes.
Future.
I just settled right over that, didn't I? Let's go to item N, which is, I've been in, come on up, Brad. I've been in discussion with Brad about the possible process changes on motions for rehearing. And the reason is because kind of looking forward with the programs that are coming to us that are kind of health related. We anticipate that there may be, as if it's not already in some instances, but the cases may be much more complex as they have to do with the scope of practice. And motions for a hearing, again, could be much more complex also. So what I've asked Brad to do is to, and actually Brad brought it before me, so I can't take credit. Brad brought it before me, and I agree. I take credit enough as it is. But a change in our motions for a hearing and how we're going to be able to handle these. There is actually, if you look at the administrative procedures of how motions for a hearing, what criteria motions for a hearing are brought back before us. If they don't meet that criteria, then the motion for hearings are not heard. So Brad is bringing forth a plan on which we can kind of streamline this a little bit more. So that's the reason that he's brought it before us for the commission to consider. So, Brad, go right ahead.
Thank you, Mr. Chairman, and members. As Chairman outlined, it's an idea that has kind of bubbled up. My staff has worked on this a lot, and then the Chairman and I had conversations about this, and I've spoken to Bill and Brian about this. And the idea is really just to look for some ways, given the additional workload for the agency and for the commission that is coming soon, to look for ways to streamline things. And what we focused on here was the motion for rehearing, maybe a small part of the commission's workload, but just looking for ways to make the process a little more efficient and make the best use of the commissioner's time in reviewing materials, preparing for the meeting, as well as just time in the meeting. And so the idea here, as the chairman outlined, is there are two ideas here. One is to, and there's not an urgency to act on this. We just wanted to start this conversation, put these ideas in front of you, and see if there's interest here, and we can move forward. We're prepared to move forward on it. If you want to vote on this today, but there's not action that's required, that's that's up to you, and I guess we'll see how the commission feels about the proposals here. But the first idea is to, as the chairman outlined, look at the changes in the Administrative Procedure Act. So in the last legislative session, the APA was amended, and it was the first significant revisions to the APA in a long time in the contested case part of that statute. And the motions for rehearing, the procedure was changed somewhat. The deadlines, the timelines were changed a little bit, how you calculate those deadlines. And the standard for a motion for rehearing, in other words, what constitutes a valid motion for rehearing, that was actually put into the statute for the first time. And the standard is the motion for rehearing must identify the findings of fact or conclusions of law listed in the order that are in error, and you have to identify the legal and factual basis for the error. So in other words, you can't just say I want a rehearing. The respondent really has to identify specific things about the order that are in error. It doesn't have to be in legalese or using any magic words, but it needs to have some substance to it and really put the agency on notice, the commission on notice, of what the error is. A good example of that is if the person did not receive proper notice, didn't receive the mail, the notice was sent to a wrong address. That happens from time to time. So that would be a valid reason. But there are some that are really not, that don't meet that statutory threshold. You know, I deserve a second chance. I've corrected all the violations, things of that nature. So the idea was to, right now, the commission hears all of the motions for rehearing that are timely filed. Regardless of what the motion says, we bring that before you to decide. The idea here would be for the General Counsel's office to kind of filter that, and if it meets this legal threshold, regardless of whether we agree or disagree with it, but if it meets that, minimum standard of sufficiency, it makes an argument, really says something, we would bring those to the commission, the notice issues and so forth. If it doesn't, we would send the person a letter. The motion would essentially be overruled by operation of law. There's a time, it's 50 days once they file it. So they'd still have the option to go to court, avail themselves of that appeal procedure. And then what we did, so that's one option. The other option, one of the issues that we address from time to time in motions for rehearing is we're revoking someone's license because they failed to pay the penalty. Once it gets to that motion for rehearing stage, then they pay the penalty, or they get into a payment plan or in good standing. What we always recommend in that situation, and what the commission has always done, is probate the revocation, assuming that they make all of the remaining payments. And so the other idea was to delegate that function to the executive director, the ability to probate those revocations. It would just sort of take that off of the commission's plate as something to address. Those are never contested. There's never really an argument about those. So,
Can I ask you something, Brown?
sure.
But sometimes we have reduced those penalty amounts by taking it off our plate, then we don't have that option.
Well, on those cases, I mean, obviously there's still going to be motions for rehearing that come before you. If the person puts some issue in play by making an argument, then that's all still going to be on the table for the commission to consider.
But I'm trying to figure out, though, if the issue is a revocation pending payment, and then we're going to probate it pending the revocation.
Mm-hmm.
If you're bypassing us and going straight to the executive director, we don't have the option of reducing the penalty if we think it's excessive.
In those cases, I don't believe there's been a reduction in the penalty. I think it's always been probated. Well, what we did, we kind of anticipated there might be that, concern. We did an analysis and went back through all of the previous motions for rehearing back to January, all for this year, and looked at, if we had applied this going, back in time, what would that have looked like, and what motions for rehearing would have come before the commission, and what would not, and that's included in your packet. And all of the motions for rehearing were denied. I hear what you're saying about that. There would be fewer motions for rehearing. to consider, so there might be fewer of those opportunities, but you'd still have those opportunities, and we didn't find that to be an issue in the ones that we looked at.
I gotta be honest, I don't like that you're taking the motions for rehearing away from us. I just don't ever think they were that burdensome for us.
Well, the intent wasn't to take anything away, it was to kind of streamline and make your work more efficient, but
Well, no, I
this is.
appreciate that, and that worked great when it was default, default motions. Because it was just reading off a list of numbers that you all had declared that had defaulted. And so we just went ahead and summarily did this. But this, I think it's a whole different level. I think it's kind of our responsibility to look at these motions for rehearing, and I don't think they should be taken away from us.
Well, and I tell you that statutorily, there are certain requirements that they have to meet.
I agree, and that shouldn't change.
Well, but the problem is that there have been some motions for hearing come before us that don't meet those statutory requirements, and we just listen to them anyway. So I think there's two things here. One of them is to move towards the statutory requirements of fulfilling and meeting the criteria of a motions for hearing. And second is to anticipate down the road what our meetings will look like. Because I think initially we're going to have a decrease in the number of motions for hearing. While the number may stay the same in the future, they're going to be much more complex, which means that we're going to have a much more discussion be taking place on each particular case that comes, each motion for hearing that comes before us. So right now, we just hear whatever comes up.
Right,
And they're not meeting the statutory requirement.
But how many do we have today?
No, there was 3, and I understand
That's
that.
what I'm saying.
But
I
it's
don't
not-
see the reason where this
and
streamlines us.
where we have 3 today, I think we had 8 in the last meeting. And-
Typically, it's 5 or 6. We had a lighter docket
Yeah,
today,
this
and I
is
think
latter
the last
document.
meeting as well.
Sometimes, I mean, it's been up to 8, normally average 5 or 6, but what I'm looking at also, and this reason that Brad brought it to my attention, was the complexity of the health cases that will come before us is anticipated to be a longer length of time of discussion, which means that, our meetings potentially could be a little bit more in-depth. And we're just trying to streamline it somewhat, because, again, if somebody says, I want to file a motion for rehearing, it comes before us and we consider and we say, no, there was no reason for you to do that. That would be off the table. That would no longer come to us.
Well, but I appreciate that Brad's group lists out in the memo the purpose for the motion for rehearing, so we have that information ahead of us. I just think we're putting the cart before the horse. I think we should wait until we see if it becomes a big issue that we need to streamline it.
Well, and I think that the only thing is to anticipate, not so much put the cart before the horse. We were looking at anticipating what the meetings would look like. That was the purpose of this.
Yeah, that's a good
Commissioner
question.
Shaw, just a second. Commissioner Shaw.
Again, I sometimes question this commission as to what our real role is and what we're doing here. I mean, part of our role is to be in the governance process and maybe look at things in a big picture sense. I sometimes feel like we should also be streamlining as TDLR is streamlining their programs and processes, we should be streamlining our programs and processes too, so that we're not inundated with an agenda that is so large, yet we can't deliberate on the issues that we really need to deliberate. And I'll give you an example. I've talked about staff reports, I think I've mentioned that several times. I can read a staff report. I don't need a staff member to go through the entire report. So if this is something that we can go back in and streamline, I'm all for it. But I do agree with the point that I think we should at least try and test it out just the way we've been doing it, and then maybe come back in, leave that option that if the agenda is so filled up and we can't get out of it, like today, we have an executive session that I think the chair talked about. We're running against the time right now. And so if we had 45 cases for rehearing, we wouldn't have, been able to get out of here. Likewise, at the same point, we don't have any statistical analysis of how big that agenda is gonna look like. So while I appreciate the chair and legal counsel going through this motion of trying to bring something back to the commission, I admire you to do that, but I think let's test it, let's try it, and then come back and visit it.
Well, and while I can appreciate that, I think the slippery slope on my part would be if we say, yes, we're gonna hear all the motion for hearing because of the fact that we have a short agenda. We have a long agenda, so go ahead and filter through those. We begin to start having two processes by which we're following, which I think jeopardizes us and opens up to liability. I think we either need to say, yes, we're gonna do it this way, or we're gonna do it this way. As opposed to saying, let's take a look at the agenda, whether we're gonna have them come before us or not.
No, sir, I'm not saying that.
Oh, okay, I'm sorry, I
think
thought
you
that was what was
misunderstood
mentioned.
me and
I did.
Yeah, so let me clarify again. What I'm suggesting is that we continue the process that we have, bring the programs on board, let's see how many motions for rehearing we have, and then maybe come back and revisit.
Oh, I see, okay.
Does that make it clear, sir?
It's a lot clearer now.
Well, another thing that may make sense is the time suck always seems to be the, excuse my French, right? The contested cases, right? So as these things, the health side, and it gets very complex, we may need to look at doing what we did on the board, what I did on the Board of Accountancy, and they still do, is we had a behavior enforcement committee and we had a technical standards review committee where we had to get very technical professionals in certain aspects, like, say, the Arthur Anderson case, and forensic accountants, and you may need a lot more health experts. So you may have to offload some of that to a committee that is, like at this accounting board, it was part board members and part public, just committee members, but they were all experts in their fields. Because this work may get a whole lot more technical.
Yeah.
That's true.
I mean,
We,
For me, I mean, Chairman, I say, put the process in place. We need to establish the process, because that's just, I think, as we go down the road, we can. It says you're driving, and if you're on rough terrain, you need to shift into to a different gear in order to drive forward. But right now, if we're absorbing everything, then that's not the most effective way. It's either we're supporting, as Commissioner Robbie noted, Commissioner Shaw, the vision of efficiency, or we're not. And so we can be moving along now if we have 2 or 3, 2 or 3, but if we suddenly have 12, now what are we going to do? Listen to 12? No, we kick that in. That's my suggestion.
Commissioner Butler.
My concerns are that the little guy doesn't get hurt. Because, I'm kind of one of those little
It wouldn't have
guys.
to be the case.
Yeah, I'm not saying it is. I'm telling you my concern. And so, what administrative process do we put in place where the one guy that has been done wrong somehow, or not through his own fault, maybe not through the department's fault, but he's fallen through the cracks? Where does he get his say? That's my only concern. So I would just say let's proceed carefully. And as cases become more complex with the health issues that we are going to be taking on, it doesn't mean that one guy or lady who fell through the cracks somehow, their case is the most important to them, and we need to be the one that hears it. So I think I'm with Commissioner Yurko and Robbie Shaw here. Usually, if those guys are on one side, I know the right decision's the other way. But, so.
well, Commissioners,
I'm just.
I think I need to go back and sit on that side of the table.
I was gonna say, you want to come down here with us?
I'm just kidding.
Well, and I guess kind of what I'm getting, which I would kind of sum up, they're not saying this is a bad idea. They're just saying it's
Not
not a
right
very
now.
good idea at this time.
understood, and I hear you on
Is that
all
clear?
that. And if there's anything that you want me to tweak or work on from this, or additional information that you want before you'd be comfortable moving forward with something like this,
Yeah.
please let me know, and we can do. Again, this was really to kind of start the conversation and
Well,
look
we
for
got that
ways
started,
to.
that's for sure. I would say let's not shelve it, let's just put it on the table right
Okay.
now.
But I
on
think
the
you wanna-
desk. Yes, Commissioner Shaw.
Yeah, can I extend that to Brad? And I love the concept, by the way. I think this is a great concept to streamline our workload so we can manage and do better things as we're here and, with the limited time that we have. So I don't think that we should shelf it. I think we need to study it a little bit more. I'd like to at least ask staff if it's a possibility to do, and maybe encourage you to not only look at the medical side, but look at all the programs that we have. And maybe create that little checklist, so that if it's straightforward, maybe this commission can vote on that and say, okay, these are the criteria for rehearing, and maybe then an executive, director could kind of look at some of those cases. That, there's a possibility in the future. I'm only saying, let's look around the corner and not throw this idea away.
Well, and I guess kind of piggybacking on that, and we'd have to have staff kind of flesh this out a little bit more, but would you be open to, in your agenda packet, having a list of motions for rehearing that we would essentially, that staff has already said, these do not meet the criteria, and let that be there, but, because I know in some governmental entities, if a elected official, in this case it'd just be appointed, wanted to bring out one of those, they could bring out one of those and just have it and say, okay, you know what, I want to take up item number X, because I think there's some merit to
referring to
what they're
consent-
saying. Yeah, consent agenda.
Consent agenda.
I'm just trying to, I'm not simply trying to do that.
I agree with the consent
Just
agenda.
simply have it some type of a consent and let us
Consent
pull it out
agenda.
if we wanted to. And give
Right.
notice, we'd have to give notice ahead of time and say, in the event that the person has time, ample time to be able to come forward.
Well, yeah, but then we would have to get these hearings, these packets too early before they have it together.
But what I'm saying is that,
Yeah.
I guess, what we could do is simply say, Commissioner Yurko wants item number X to be heard before the commission because she feels that there's merit to what they're saying, and then we can place that on the next agenda.
I understand
just
that, but
pulling
I
that out.
think there is a clock running on motions for rehearing. Isn't there a clock
But I
running?
think once
There's-
they've notified us,
Yeah, we can extend the clock if we need to have the commission actually hear a motion. We do that routinely. We send out a letter. It's up to 100 days after the order is signed, so that usually allows enough time for it to be
what's
heard.
the commission's thought on that? Kind of having a consent agenda that we can pull out on our own.
I still think we need to wait and see what we're.
Yeah, my
This
recommendation
used to be a
is,
two-day meeting. We've already streamlined it to half-days.
yeah,
So,
Mr. Chairman, if I can offer something, just a step before that, is we can have the staff do the analysis of everything's coming to you as it normally does, but keeping track of the motions for hearings that would not have come to you, so we can track that for about the next 3 or 4 meetings and saying, you're getting all 12 of them. However, these 6 would have been pulled out based on this filtering process going forward. And we'll have the data of what that looks like going forward, and I think that's really going to be the test, because the concern is what's not going to come to you. And I think if there's comfort that the ones, the small guy and all the ones could be heard, I think you guys are going to probably lean towards the efficiency. If you find out that, no, those are 3 that we made a decision on that would have been other than what the staff would have made. So it's going to give real data points versus just kind of filling out, and it doesn't change the process dramatically from a consent to a non-consent.
And Brian and or Brad, is there a process flow map that's capturing that? I mean, where are we? I'm kind of a visual.
We can build that now. We can use the process that Brad has outlined.
Which has the timeline to go with it.
It'll have the timeline built in. It's going to look, from your end, it's going to look exactly the same. From our end, we're going to measure and have data that says these 5 would not have gone to the commission under this modified process. And then we can come back to you after your 3rd meeting and say, out of the 25 that you received, 4 of them would not have come to you, and you took no different action on those 4.
Yeah. But, Mr. Chairman, I suggest that we don't, put it on the back burner anywhere, that we put a model in place. I'd like to see a process flow map. It's just how I think from the visual that has the timeline and touching base on Commissioner Butler's, making sure that the smaller entity is not overlooked. I think that's the path to go. Also speaking into, I know that Commissioner has mentioned about the dashboard on a couple of occasions. We ought to be driving with that tool and this information that's captured to make sure that we're doing and being in alignment for what we're charged to do on this board. And if you need help in that arena, just let me know.
Commissioner Collier, along those lines, I met yesterday for about an hour. I met about an hour yesterday with our black belt on the dashboard process, so it's something that we are continuing to modify and really trying to figure out.
One of the things that Commissioner Yoko just mentioned is that, something for the commission to consider, of course, just coming up, food for thought, is that maybe every other meeting, we have a 2-day meeting as opposed to a 1-day meeting.
We used to do that years back. We met every other month for 2 days, rather than every month for a day.
I'd rather do that.
that's the thought. So anyway.
That's what we did at the county.
So it's just something, food for thought, kick it around, we'll go from there, so.
Thank you. I think we have some direction, and in the interest of efficiency, I won't take up any more of your time.
Yeah, the
but,
directions kinda look like
we'll,
that.
It's a little late for that.
Put it that across.
Yeah.
We appreciate
Yeah.
Thank you.
That commissioner, I mean, that direction's kinda going in all different directions.
There's a lot of different
Yeah.
ideas, and
The irony.
we'll.
Yeah, exactly, the irony of it.
Brad, thank you so much.
Thank you,
I know
appreciate
that's
it,
a lot
Brad.
of work.
Let's move
It's not
on
wasted
to,
work. It's not wasted.
well, let me ask you this, how quick, who's doing the staff report, you and who else?
George Ferry.
Okay.
Mr.
Can we
Chairman.
be expedient, because we've got ice floating over here.
I was gonna tell you, in the interest of time, we can pass on the staff report and the advisory board reports for this meeting.
Yeah, if you guys are okay with that, because I know we are pressed for time, and I can tell you, I need to change my flight, so, for later
George wore
on.
a suit.
Yeah, I'm sorry?
But George wore a suit.
George, do you mind standing up so we can see your suit? Thank you, appreciate it. Now we've seen his suit.
I'm good.
We're okay. I would say one thing. At this point in time, we would always go to the staff reports, and we'd have our executive director bring in the report. We're gonna let you off the hook this time, Bill. You don't have to do a report. But what we do want to do is to have you come forward, because we do have a gift for you that we want to present to you on behalf of the commission for the work that you've done. I'm going to allow the commissioners to be able to speak on their own behalf also. But I want you to know that, as was mentioned in the meeting last week, and remember, you promised not to cry. In the meeting last week, you have impacted the state of Texas. And when you begin to start taking a look at the impact of individuals that have impacted the state of Texas alone, you begin to start talking about governors, you begin to start talking about David Crockett, you begin to start talking about everybody that had an effect on Texas, and you've done that with what you've done in lowering fees and the efficiency that you provided for Texas and running this state agency. I have seen firsthand what you have done, and I know that what you have done, your heart and soul has been poured into this agency for the last 17 years, but more so as a public official for the last, 41 years?
Yes.
41 years as a public official, and so but I know that you have public service in the heart, which is the true impact of the core of an individual, when you know that you're willing to serve others, knowing that you may not receive anything in return, but you want to do that yourself. So I want to thank you on my behalf for what you've done. So, Commissioners, anything you would like to say? I'll open it up. If not, then we'll move forward.
I do have one comment. I realize that we've known one another for a long time now, and I appreciate that. But I do appreciate the legacy that's in place, because that rings volumes for years going down the road. So you've given it a solid foundation, and I'm a believer in foundations that we're building upon, and so we're already on the highest mountain right now. So thank you for that.
Thank you. And for tearing up, the announcement, 4 months ago, that was an emotional point. I told Sharon Hamoy, I said, you're gonna have to help me with retirement, because I've never done this before, I don't know how to do it. Well, the staff helped me out on that, because they broke up the soirees among the different divisions, so that I could spend some time with the divisions into several different events. And we were able to have some really good times where we could talk about the effect that I had and the things that we've accomplished together and some of the good memories. And it was really nice, because it was a happy occasion. It wasn't emotional at that point. So up until now, I've been okay on the tearing up, except for, and Commissioner Roadball saw that, when the legislature, when we had the meeting over there, Trey Seals made me cry because of the song that he was singing.
We can bring Trey back if you'd like.
Yeah, so.
So basically what he's saying is that he's numb to the commissioners at this point in time. We do have a card we'd like to present to you, and also a gift on our behalf as commissioners, and again, we want to thank you for what you've done.
Thank you.
Yes, please do. And I noticed, that's a good question, we got purple, I noticed that Kate's wearing purple, I noticed that Brian's wearing purple.
Purple wall.
I know we have a
We have
purple
a
wall.
And if you've been to the executive office, we have a purple.
Yeah,
wall there.
Yeah.
we have a purple painter.
Oh, that's beautiful. Cufflinks.
Tragic if you won't use them now.
That was a good
That's the irony. You're retired.
It is 12:25. I can tell you that we're going to enter an executive session under Section 55107 of the Government Code to discuss personnel matters pertaining to the executive director. So it gives us time to go in and everyone can congratulate Bill on the room.
Thank y'all.
Did you change mine? And we're exiting out of executive session. Let's move forward. Public comment. Mary Jo, I apologize. I probably should have taken care of you ahead of time. And,
Nina.
I'm sorry, Nina. Nina, I'm sorry. I don't know where Mary Jo came from.
They said she was gonna be here all day. Next
She did.
time.
Well, she literally is here all day. So she's got public comment concerning driver's education. According to our rules, we'll give you 3 minutes in which to be able to make a statement. So if you don't mind, again, just state your name for the record, and you have 3 minutes.
All right, thank you so much for allowing to have public comment. I do want to take this opportunity to thank the TDLNR and express our appreciation for how we've been treated. We're going on a year now, September 1st, of being transferred here from the Texas Education Agency. And statements made before the transfer, I must let you know from the staff, from all divisions, because I kind of talked to everybody during the legislative session and prior to that, have rung true. Kept hearing from people, you don't have anything to worry about. Well, I'm going to worry. Can't change that. But we've been treated like we're wanted. And I will say that is enormous for our industry. And like we're human, there's been transparency from all the divisions, the executive staff, the legal staff, and we just want to put on record, and I know I've provided written comment also, that we appreciate that and so forth. And I greatly appreciate what y'all do. Because the first meeting the commission had after the governor signed the bill, I came and to learn, and today I learned a lot more. And each time I come here, it's y'all have an enormous task, and I admire the passion that you approach that with, and I thank you for that. Do want to wish Bill great endeavors. He got us here, and I approached him and said, "You got us here, now you're leaving." So I didn't know how many statements that he had made were going to ring true because of the continuity and so forth. I appreciate the commission for who they placed in that position, and I will let them know that I have nothing against Oklahoma. The most famous person I know was born there, so that's very true and so forth, even though the hat's not here today. Oh, never mind. Safeway Driving does want to put its support behind this partnership. And again, you have my contact information. Anything we can do, we will try to do. We understand, and do not forget, you're an oversight agency here. That's right there on my mind. I can handle that and go forward, but it is a partnership for the citizens of Texas and their protection. And I do want to challenge you, and I've challenged staff here with the same comments, gone statewide for our industry, and continuing ed, same thing, that the decisions you make concerning driver education and safety, please consider our students' educational experience first. Leading cause of death of teenagers is a motor vehicle crash. According to the NHTSA, the CDC, AAA did a research study over 10 years that our teens are actually killing more others as a driver than themselves, which means they're killing their passengers, pedestrians, people in other vehicles. We have an enormous task in the driver education safety arena, and to look at lowering any of those standards for those student experiences is just not something on our radar. Safeway Driving takes driver training seriously. I think education should be fun, but not funny. You have academic failure in other subjects, ours may lead to death. And so any decision that you make or TDLR makes, that you do look at that educational experience before making those decisions. As you look at the size of crates and cages for animals, take our young people, the top 10 leading cause of death, according to the CDC, is a motor vehicle crash for all ages. So don't want to just dwell on the young people, but that's a high concern for ours. And again, if you have any questions, comments, because I know everybody's got a flight, please feel free to contact us, and you'll probably see me here again. But thank you so much.
I appreciate it. Again, I apologize for holding you to the end. I should
Oh,
have put you in there before. My apologies.
I mean, thanks for being here as well, and I appreciate you introducing yourself earlier. And I know that as for the 5-year term that I'll be on this board, and excited to do so, we'll see more of the inclusion of driverless cars and vehicles.
Oh,
And
let's,
so that's going to be.
that's another question.
Yeah, well, we'll
Is
deal
it
with that
driverless?
down the road.
Does it have an operator or not? Okay.
I appreciate
I'm
that.
good.
Thank you, I
Thanks.
appreciate it. Let's move on to item R. Commissioners, we have a meeting on October the 5th, November 16th, and is there a need to have a meeting in December, or are we going to go into the first part of January?
Mr. Chairman,
Do
I
we
think
know?
we'll go in the first part of January. We took a quick look at 2015, which was the last legislative session, and our first meeting was January 28th in 2015. So we may be able to do a third week meeting in January.
Oh, wow, that's going to be long
Um,
after November then. Okay.
Yeah.
That'd be a good break.
But we didn't have one in December that year, so, or the previous year, so I think we can handle that. We will, if anything changes, we'll bring it up at the next meeting.
If you don't mind, Kate, get a date, potential date, and send it out to the commissioners so that we can go and kind of pencil that into our calendars. Right now, we're looking at the third week of January, which would be the Wednesday, third Wednesday
Yes,
of
sir.
January. I
That'll
would
get
say
us the
tentatively,
week after the session starts, so
which I
we may
believe
have.
is going to probably be around the
18th.
18th. So let's tentatively say January the 18th, so we can put it in our calendar for right now, and then kind of go from there. So, Bill, parting words.
I'll come back on the 18th for public comment.
Oh,
How's
my
that?
gosh.
We'll put you last.
You gonna tell us what you really
You
think
need
of
to do
it?
it this way.
Yeah, the Bernie fingers, you say?
Yeah.
Oh, my God.
Yeah, we will definitely put you at the end. So, again, thank you for your service.
It's been a blessed career that I've had, and the times that I've been able to spend with the staff have been really gratifying, because I feel like I've made a mark on things. It's nice to be appreciated.
You've done so much, Bill. You've just, I mean, you've met so many people. What has it been like to serve with me?
Let's just poke on that
You mean
comment.
St. Tom?
Yeah, we're actually,
Y'all didn't see
we're
his
trying to get
photograph.
out of
Where's
here.
that picture?
A motion to adjourn?
Yeah, we're trying to get out of here. We don't
You
need that
should
to
have seen
happen.
his photograph. It had stars.
I know,
like-
I heard about it.
Mr. Chairman, I think there was a motion.
Yeah, there was a motion to adjourn. Also, real quickly, everyone, you've got your legislative appropriations request. Review this, take a look at it, and make sure that you understand what we're doing here, because if you've got any questions for staff on this, feel free to contact them, because you do have them for you.
And Mr. Chairman, we'll be doing a presentation on that tomorrow for the joint budget hearing, and so we'll let you know how that goes.
Sounds great. I think we've covered all the items, is that correct? Okay.
Yes, except for staff reports and the advisory.
And that they can read it, and I think Bill stated we could read it, and advisory reports we can pass on, so we will do that. So that being said, it's 2:07, and we are adjourned.